We're going to wait for a few minutes. You can enjoy your tea, PP. Colleagues, it's now 10 minutes past 10. We are ready to start. We were ready to start at 10. Myself here as a chair, the public protector here, Advocate Mbofu, the legal team, evidence leaders, members of the media were here at 10, the support staff and members of the public were waiting for the members. So the members have just allowed us 10 minutes later to start, just to put it on record. So we're now ready to start on this day, the last day of March, day 6 of the testimony with Advocate Mkhwebane. I again want to welcome all of you to our meeting. We're continuing today. Advocate Mbofu would have, especially on this charge, laid the pillars that we're going to focus on. We're left with the qualifications as well as what he terms the general issues, which I'm not able to pin down, but I will not punish him for that. So these are the two areas that I think, unless I'm missing something, as we delve into the unit charge. So I want to immediately, having started 10 minutes late into their time, to hand over back to you, Advocate Mbofu, to resume the day. Thank you.
Thank you, Chairperson. Well, I can see that you want to restrict my scope. But I did remind you.
I am aware of those 9 areas where we covered 5 of them or 6.
We covered about 5 of them.
Yes, because you are interposing them.
Yes,
so.
yes. Okay, good. No, that part. Then that was the only complaint. Yeah.
All right.
But more on a positive note, Chair, you'll see the approach I'm going to take actually is going to continue to be to deal with them simultaneously, and I will, for lack of a better word, defer the qualification issue to the end, because what I want to do is, remember, the qualification issue features on the 6, but it also features on the 9. So when I do it, then we know we're done. Yeah.
That's in order.
Thank you, Chair. Chair, okay, I know you are allergic to issues, as you put it the other day, but unfortunately,
just to indicate that we will have a slot for those.
For the issues.
Yes.
When?
We're not going to start with them.
Okay, but well,
we're looking at after lunch,
after,
maybe just an
after
hour
lunch, after tea,
end.
maybe.
No.
We're planning to deal with it.
I will indicate that.
All right.
But yeah, you keep them.
Yes.
Thank you.
No, thank you, Chair. Let me just check with the public protector, because she asked me to raise the issue, one of the issues now. So, public protector, I don't want to do side deals with the chair. Are you happy with?
Good morning, Chairperson, members, evidence leaders, and everyone. Thank you so much, Chairperson. I think it was going to help to raise it in the beginning because of it relates to a very serious, and whilst you still have a lot of members possibly regarding the issue of the legal fees, but and the responses, yeah.
I'm aware of that. Let's keep them as part of that package that we can deal with them later. I want to ensure that we have the flow. I will not forget, we'll come to that. Thank you.
Okay. Well, I'm saying okay, not as if I agree, but let's do as ordered.
I'm aware of the protest
Yeah.
as it was
It's
in
noted.
July.
Yeah. All right. No, thank you, Chair. We will then deal with, let me put it this way, Chair. Our aim, and I don't think we're going to achieve it, but our aim was to try and finish the first statement. In other words, not only to cover the issues that you've raised, but to dispose of the full first statement so that we can have only the second statement outstanding. But I can assure you that even if we don't achieve that 100%, we will be very close to doing that. It's just better to have a natural break at a particular point. Okay. Chair, as I've already indicated, I've come up with a method that might even move us quicker by trying to start first with the outstanding issues on the list of 9, so that when we do the qualifications issue, then we will be basically wrapping up both lists. And that is made possible by the fact that the outstanding issues on the 9, some of them are really quick and for reasons that I will explain now. Just to remind you, Chair, that on the 9, we had the issue of jurisdiction. Remember that one of the grounds for bias was alleged to be the fact that the point we dealt with yesterday, that the PP exceeded the 2-year thing. Yes, so that we've dealt with. The second one is the second one that we've dealt with is the issue about the Sikakane report being widely discredited. There's just one loose end there because there's also a reference to the KPMG report, but that will be quick. The third one that we have dealt with, of course, extensively also even with other witnesses, is the issue about her having not seen the IGI report. So that I think has been exhausted in different ways. And then there was the issue about so-called misleading Parliament around the Gupta issue. We've also dealt with it when we were doing the other 6 issues. So what is left in that list is 1, 2, 3, 4. If we put out the qualifications issue, but let me start with the quick ones. Public Protector, there's you'll remember that, and I'm starting with this because it's almost related to the jurisdiction issue and also to something that we raised around CR17 regarding the code. Remember that one of the grounds upon which Judge Bakwa and the others made that overall finding of bias, stroke, dishonesty, and so on, was that you had allegedly attacked Judge Potter.
Correct.
Right. Now, this actually is related to the previous point. Remember, I made the point about the I think what Mkhwebane CJ calls the magnification and the failure to do by some in the judiciary to do unto others as they would like to be done to them.
That's correct.
Now, this one is quite a strange one because in a nutshell, well, firstly, let's start with the innocent part. This issue is clearly related to the confusion between the 2000 and the 2007 code which we dealt with extensively under the heading of CR 17. So we won't go there, we won't even put them up.
Correct.
Everyone knows now what we're talking about, correct?
Correct.
Right. And it's about this perennial confusion about whether is it willful or willful and inadvertent or willful or inadvertent that seems to have afflicted everyone, the judges, the president, even at some stage, the Constitutional Court, you, and perhaps to some extent some of your investigators. But I think we now know where it comes from. Right?
That's right.
Right. Now, with that benefit, and in fairness, it's a benefit that the committee has over everyone else. I think the judges, when they made their comment, they were not aware of the confusion. The president was obviously not aware. The Constitutional Court was not aware. You were not aware. But at least now, I think this committee, if there's one thing this committee will have contributed, is that mix-up has been cleared. Okay. Now,
I think it helps a lot because now if we have fair reporting as well in all the sphere, like mainstream media, like your legal brief, if they can report
forget that
correctly, yeah, and not sensationalize issues, it will help even all the lawyers as well, so that they can understand that this confusion has been cleared.
Yes. And
Just a pause, Advocate Bauer.
Advocate Mpofu, just so that we're on the same page, when you talk about the mix-up and a confusion, are we in agreement that the 2000 code was the law and that the 2007 code was not the law?
Thanks, Chair.
Thank
yes,
you. Okay.
That's exactly what I think has been cleared here, that that is indisputable. What I'm referring to is the fact that the Constitutional Court, the Public Protector, the President, to some extent, as we will show, at some, and as I said, the investigators clearly worked under a misapprehension. And I don't think any of those people was doing it just for some nefarious purpose, especially the Constitutional Court.
I think we can start with the former public protector as well.
Oh yes,
Those
and
are
of course the
we
former
should show.
public protector applied it in the Nkandla case, which is what led to the Constitutional Court applying it as well. Yes, that's correct. Yeah. And as I say, all of those people, including the former public protector, were victims of some confusion. I don't know where it came from, and I don't think it's important for us to trace where it came from, but it just got perpetuated. Yeah. But I was saying public protector, yeah, and you're quite right. And I mean this, whatever comes out of this process, at least that's one contribution that it would have made, which was because we then had to drill into it, and I think we were able to identify it, even if we don't identify its source. Now, with that background, knowing what we now all know, obviously, if anyone, whether it's in your office or the next public protector or whatever, fell back into that confusion, then they would only have themselves to blame, because it has now been clarified.
Correct.
And indeed, your office, you in particular, since those occurrences, has now been applying the correct code, and we have demonstrated that in some example. I can't remember which one.
It was the Pala.
Oh yes, yes.
31 questions.
Absolutely. Well, in the Pala investigation, the 2000 code that Advocate Power refers to was used as the basis. Correct. All right. But let's put all that aside. Now, what you were accused of and let's go to paragraph 58 of the judgment, Chairperson.
And the page?
Paragraph 58 of the judgment.
Which page is it?
Paragraph 58.
I'm saying the page.
4034
Yeah,
on
I'm
mine.
just searching with the page.
Or the big ones. Yeah,
Yeah.
4034. Okay, Tsepa's got it.
Not
Have
the
you got
big
it?
one.
Have you got it on your
No, the small page of the judgment.
19?
Okay, thank you.
Okay.
Yeah.
All right. Okay, I won't read the full thing. Let me just read out as I say, by now everyone will be able to recognize this. It says there, but what compounds the public protector's misdirection is that she then makes a complete about 10 by departing from her report and now argues that an quote inadvertent or mistaken misrepresentation violates the ethics code. And then it quotes the paragraph where you refer to the ethics code in the it quotes the Judge Potterell's summary of that ethics codes issue. I won't read that out.
Yeah.
And then at paragraph 59, it says Potterell J, with reference to the express wording employed in the executive code, held the view that what is required is that the misleading statement must have been willfully, and that innocent mistake will therefore not fall short of section 2.3a and so on. And then 60 is where the criticism against you is then leveled. They say that she even goes as far as to accuse the learned judge of, quote, a gross misinterpretation of the code and of deliberately omitting words from the code. You see that part?
I see the
Yeah.
part, yes.
Right. And then it quotes your affidavit, the same, again, it's the same confusion about willfully and inadvertent and so on. Paragraph 61, again, they say to claim Potterell J deliberately omitted the words inadvertently misled from the actual code is astonishing. Besides being a public protector, Advocate Mkhwebane is an officer of this court and owes a duty to treat the cause with the necessary decorum and so on. And the lay at the bottom, this clearly held the possibility of misleading the court. The previous sentence is important because that's where it's now alleged that this confusion was deliberate on your part. Yeah. What makes this reprehensible conduct worse is that the remarks by Advocate Mkhwebane were made under oath when she ought to have known about the falsity thereof. I think that's the punch. This clearly held a possibility of misleading the court. This conduct becoming of an advocate and officer of this court, she owes Judge Potterell an apology. The registrar of this division is requested to send a copy of this judgment to the Legal Practice Council and so on. So effectively, because of this mistake that everyone since your predecessor has been committing, you are now supposed to be sent to the Legal Practice Council. Now, the point I want to make is this, Chairperson, so that we don't spend too much time on this. You will remember, Public Protector, that Judge Jafta, for the majority, of course, had made a similar accusation against you.
Correct.
Yes. I think the only difference, Chair, is that, ironically, while you were accusing the judge here of taking out the word advertently, Judge Jafta accused you of putting it in. So, but it's clear now that both of you were wrong. Both him and you effectively were suffering from the confusion that we've spoken about, correct?
That's correct.
Yes. Now, here's the thing.
But maybe let me just clarify this.
Yes, of course.
Judge Potterell used the 2000 code as is, as you've read it. On my side, I used the 2007 code and indeed quoted it as is. And indeed, when I read the judgment, I thought, why only use willfully? And I think you'll see, I indicated, Chairperson, in the Busasa report, where we were using, where Mr. Mataboge used the 2000, but mixing it. And I had to respond and say, no, use the 2007 code because there was still that confusion. Yes, I agree that it was done under those understandings.
Yes.
So, yeah.
Yes. And don't get me wrong, I'm not saying it was the exact same thing. As I say, it was almost two sides of the same coin. But all I'm saying is that all of it emanated from this confusion between the 2000 and 2007 code.
Correct.
Right. Now, this goes back to the issue that we closed with yesterday about and what I said, Justice Mkhwebane issue about the magnification of your mistakes and the refusal to do to you as people would like to be done to them, as it were.
Correct.
And the issue is this, and I want you to comment in your own words. Why is it that a judge can, for good reasons, without any malice, hopefully, can attribute to you the act of deliberately inserting words, but when
Actually
you
creating my own
yes
code to suit the facts.
even
Yes.
worse, yes. But when you say about a judge still laboring under the same confusion or generally affecting everyone, you say the judge deliberately omitted the word. As I say, two sides of the same accusation, if you like. But in the case of the judges, actually 7 or 10 of them, who made that mistake, that's fine. But when that same mistake is now made by you, no, you are, it's a, what is it? It's a falsity. You ought to have known about the falsity thereof. It holds the possibility of misleading the court. Conduct is unbecoming of an advocate and officer of this court. Owe the judge an apology. The registrar is requested to send a copy of the judgment to the Legal Practice Council for consideration. Can you just comment on that inconsistency or incongruency in judging practically the same thing?
You know, it's what I was referring to also yesterday, that it's so unfortunate that sometimes when it comes to me as the public protector, a lot of things and a number of things are changed. And I could pick up that whatever I do is just actually blown out of proportion. And definitely in this particular instance, also with the narration, it's so unfortunate that sometimes some, and I've always been saying that, judges will just go with what is being reported out there. And as I indicated, I was reading some article, with legal brief. Well, somebody shared that article. And it's so unfortunate that a lot of lawyers, a lot of possibly judges, they read because they should be reporting about AMA cases and whatever. Is it necessary for them then to as well sensationalize, that, okay, Mkhwebane represented by Mpofu, who also represents Zuma, and bring in factional issues? Stay away from that. And unfortunately, then they have this perpetuation, which when judges read such things, I'm not saying all of them, they then take it as a truth because they think this is how things. So this was not my intention. And if judges were objective, they were supposed to read the code I have mentioned in my affidavit and compare to the code which Justice Potterell has referred to, and objectively say, I mentioned or I indicated that she might have removed something or omitted the advertently or inadvertently. That was a genuine capturing of the code as is. So I think judges should have sit back and reflected and say, okay, Mkhwebane, you have this code because it was attached in 2007. You relied on it. Potterell, because Mr. Godan is also relying on the 2000 code. So, there's also a lot of, for me, what I've seen is that the choreographing, which I can also honestly say, you find sometimes a minister or somebody mentioning or former judges having that platform in the mainstream media because they are given that platform. Comment about Mkhwebane, the way she doesn't know the law, the way she's so rogue. And that is taken as if it's like that. Instead of a judge, because for me, when you are legally trained, objectivity is key because you need to listen to both sides of the story. And also when you are a judge, then you have all the records before you. But now this way of capturing it in my affidavit, I was also saying, no, Judge Potterell, you cannot mention that because I know this code. And it was a genuine response. But now I'm dealt with like the way I'm dealt with.
Okay.
So, and these comments, unfortunately, they were taken directly. You know how this choreography is sometimes? It's from this member of the executive or from this litigant into their affidavit, into media, into a judgment. Now, a number of them, if you can analyze and read the Mazon, Honorable Mazoni's complaint or motion, it's a seamless thing. And the comments by judges, falsity, dishonesty, and now this opportunity, Chairperson, as you mentioned yesterday, thank you that you understand that for me to prove myself that when I was doing it then, it was just purely because the law before me, the code before me was saying this. And now when you come and mention something else, I'm like, why is she mentioning the following? And all of us are fallible. I think Justice Kampempe in this matter also, when it was taken to the Constitutional Court, this way, and even the three judges or others were saying, yes, judges, we are also fallible. Do unto others as you want it to be done to. So I can go on and on and on because it's very painful for me to be subjected to this and everyone just ganging up.
No, that's, well, it's how it works. It's called manufactured consent.
Mm.
But that's a story for another day. Yeah. So this ground then that you must be, and you say it's a seamless thing. So it starts with Mr. Kodan, who puts this spin onto the issue in his affidavit. Then it gets imbibed and is put in legal argument. Then it gets reflected in a judgment like this one. And then that's it. And all of us, then finds itself into the impeachment motion of Ms. Mazzoni, which is supposed to be binding to Parliament. There's nothing Parliament can do about it.
Mm.
And off she goes. Yeah. But anyway, hopefully we at least this process will break that chain. Yeah. All right. Now, when it comes to what Matlanga J in the SARS case called, and I'm paraphrasing, the almost automatic or knee-jerk or fashionable imposition of personal costs against you by judges, particularly in the Gauteng High Court.
Mm.
Which in respect, what he called the disturbing frequency of that happening.
Mm.
And the consequential undermining of the weakening, I think is the word he used, of the public protector office, as he said, irrespective of the incumbent.
Mm.
What can you propose that this committee, for what it's worth, because as it happens, you also account to Parliament, can do if it agrees with Justice Matlanga's analysis or the unanimous Constitutional Court's analysis in that matter?
Because, well, it's the similar, I think you mentioned it in the context that we are dealing with the Pretoria High Court and all the matters which we've litigated. And again, Chairperson, the litigants having to litigate through that particular court and us defending the matters and opposing because we want firstly to assist the court, secondly, because we would want to make sure that the mandate of the public protector is not impacted and we are able to do our work without fear, favor, and the independence. Now that judgment also says to you as members of Parliament, and you are sitting here representing the public and the people, how do you make sure that the legislation which you have crafted and indeed those are to the advantage and to the benefit of the people or the masses which you represent? So unfortunately, then issues of personal costs commence like this on the person of the public protector, because then it also reflects on the investigators who are doing the work. They might say they are dealing with me as the incumbent, and we've shown some of the judgments by the judge president. One public protector is a different judgment. Another public protector is a different judgment. So I think that impacts a lot on the precedents which they are setting. And forget that currently we are a generation which will have to make sure that our generations and generations to come are not subjected to this confusion. Unfortunately, Chairperson, I will say this, and I've said it before. Unfortunately, the system, the way it operates, it will use any gap which they find and use us to be continuously oppressing and continuously impacting or creating a situation where that constitutional gift of an institution is not serving the masses, but the status quo remains. Those who have money, those who have capital, they will continue litigate through the courts, and they will leave the people hopeless and not having anyone to assist. So unfortunately, that's how it's happening. So one being this institution trying to empower the public and not allow abuse of power and not allow those who are in power to abuse the system, the resources, and be the law unto themselves by not complying to whatever law. So it was just intentionally done to improve. But now when they say personal cost, what does it do to me? What does it do to my family? What does it do to my successors? And even other Chapter 9 heads, because there was this instance where we discussed this FISD and others saying, but if one was even working a CASA, saying, then there's a lot of litigation because that space as well, capital would want to see themselves. Now, if you stick to the policy, they'll take you to court and they will even clobber you with personal cost, which is totally wrong. And maybe if that can be turned around by another administration and we also subject judges to the same process, I don't know whether they would like it, that it's done to them, because it's not right. I mean, or any member of the police, the nurse, and everyone who does their work as a public servant. And then when you do any mistake or something, then always you must pay from your pocket, which is totally wrong.
Yes.
Hence, it goes back then to the issue of the constitutional democracy, which we're speaking about. I think as members of parliament, which possibly currently we've started debating about, to check, is it really benefiting the masses? Is it really assisting in this situation we're facing as a country?
Yes. And now linking that phenomenon, and as I say this, I mean, I don't know what Parliament can do about it, if anything. But I suppose the ultimately is South Africans out there who must resolve these questions, or decide if they want to have a public protector or not, and if they do, how it must be protected. Yeah. But and Chairperson, you'll forgive me, I know that I've read this before, but I think this is quite an important part of what we're dealing with. Which is what was called in the CR17 judgment by Mkhwebane CJ, the heading is the magnification of the public protector's errors. The magnification of the public protector's errors. And I just want to pick out on something that you have just said now. Where he says that the following wisdom-laden words of caution by Madlanga J encapsulate the concern I have about the treatment of matters involving the public protector, Advocate Busisiwe Mkhwebane, particularly her findings and recommendations or remedial steps. Although the context was different, the message or principle is just as opposite as telling in all other cases. There, Madlanga J said, there appears to be a developing trend of seeking personal cost orders in most, if not all, matters involving the public protector. Courts must be wary not to fall into the trap of thinking that the public protector is fair game for automatic personal cost awards. Whether inadvertently or otherwise, the High Court judgment in the EFF versus Godan matter, and in that instant matter, are instances where the High Court fell into that trap. And he said, I voice those words of caution because of the disturbing frequency and regularity of applications for and awards of personal cost orders against the public protector. What is particularly disturbing is that it is clear that the applications and awards are not always justified.
Mm.
And then now, Mkhwebane is speaking for himself, now says, there is indeed a disturbing tendency by some of us to, presumably without intending undue harm or injustice, unduly magnify virtually every error of the public protector, real, mistakenly, or perceived, or rather real or mistakenly perceived. This is quite surprising because judges with more experience as practitioners before their elevation to the bench and with more years of service as judges, that the 10 years minimum requirement as an advocate or the mere fact of being a judge, regardless of how long to be appointable as a public protector, have committed similar or more serious errors. And we are not as harsh on them, or should I say on ourselves, as rightly so. Then he makes that example about himself that I won't go into. Then he says at 201, Chairperson, without any basis, in fact, and sorry, let me just pause here. Chairperson, this is particularly more important because this relates to a case that's before this committee, the case of Commissioner for SARS versus the public protector. You'll remember it's the one where in the Mazone motion, it only relates to the High Court judgment, but we all accepted that we will incorporate the Constitutional Court judgment. He says, and that's probably, well, I was in that case, probably the most insulting and scathing remarks were made against the public protector. And if we had not appealed that case, those would be, I'm sure the Mazone motion would then almost look better than it does. Fortunately, the Constitutional Court reversed it. Okay. He then says, Justice Mkhwebane, without any basis in law, Mabuza J, that's the judge we appeared for before in the lower court, concluded in Commissioner for SARS versus Public Protector that the Public Protector had a, quote, proclivity to operate out of the bounds of the law, and, quote, a deep-rooted recalcitrance of accepting advice from senior or junior counsel. And this was cited as proof of her unreasonable, arbitrary, and malafide conduct. He went on to order punitive costs against her in her personal capacity, a shocking and most unjust decision under the circumstances. And then it says, similarly in Kabinda, this court held 2 of its members had erred. What all of this means is that the manner and extent which judges and magistrates criticize litigants, legal practitioners, and witnesses should be a mirror image of the same measure of criticism they would find acceptable under comparable circumstances, were it to be meted out to them by their colleagues or practitioners or the public. We must therefore do to others as we would have them or others have to do to us. Now, that I think is what you call the bull's eye, where the issue that we're discussing now, a criticism, you criticize a judge and the judges criticize you, but he says then that the judges, their attitude should be a mirror image of the same measure of criticism they would find acceptable under comparable circumstances, were it to be meted out to them by their colleagues. And then about the real issue now, which is the 2 codes. Then she says, that said, I am also concerned about any notion that she somehow amended the code without authority.
Okay.
Just pause, I've got to move.
I just like to place on the record, you've read this several times into the record. And on each occasion, you've missed paragraph 202.
Paragraph?
Slip from 201 to 203.
Okay. All right, no, I'll read, I can read the whole judgment if you want. And as for your first part, you don't have to place on record what I've just said a few minutes ago, which is that the chair must bear with me because I've read it before. But
I'm placing on the
yeah.
record that you've read it several times before, and on each occasion you've skipped paragraph 202.
So what are you
to
suggesting?
203.
That I'm doing it
Perhaps you
deliberately?
should read it, Advocate Mkhwebane.
Yeah, I'll read it. Or you can read it when it's your turn, actually. I'm not going to read it. Unless if you're suggesting that I'm doing it for dishonest purposes.
We'll get an opportunity to argue this.
Well, then don't take it now. All right, I'm not going to read. Let's go to 203. He says, and this is the reason I'm jumping to that is because it is the one that deals directly with the issue of the code. He says, that said, I'm also concerned about any notion that she somehow amended the code without authority. I think hers was more of giving a wrong meaning to a legal instrument than amending it. Anyway, that's I think we've covered. But maybe let me indulge my learned friend by reading 202. It says, there can be no doubt that the public protector was wrong in certain respects. For that, she deserves to be dealt with appropriately. And it is for this reason that I have to reiterate my support for Chapter J's assertion that she went overboard in making the supervisory order against the police, the National Prosecuting Authority, and Parliament. That's a different matter. It was wrong of her to conclude that the President deliberately misled Parliament to use willful and inadvertent interchangeably when the two are mutually exclusive. The same applies to aspects of her remedial action alluded to above. That manifests some overzealousness. Okay, well, I don't see how this actually helps the prosecution, because the Justice Mkhwebane is saying here is exactly what we're saying, that it was wrong to use the 2007 code. Everyone knows that, yeah. That's not what this inquiry is about. It's not whether it was right or wrong. It is whether the use of that code was done with an intention to target certain people. Correct. Or as an honest mistake that everyone else was making. And unfortunately, that point is missed miserably by the evidence leaders. But that's the very point that he's making. And even in the CX judgment, where Justice Mkhwebane and Justice Goliath say that you are being blamed wrongly, there are 2 or 3 criticisms which they make. Correct. Some of them you actually considered by not opposing a certain matter. That's not the issue. The issue is not that Advocate Mkhwebane is an angel who is infallible, who does not make mistakes like you and I. The issue is that where she makes mistakes, like all of us, the same measure of criticism that you would find acceptable under comparable circumstances, were it to be meted out against you, must be used. That's the subtle, maybe too subtle message that is missed.
Don't be tempted to get into an argument.
I know. No, Chairperson, it's just I don't like to be falsely accused of not reading things that are actually helpful to me. But anyway, that's fine. Let's let that pass. So, Chairperson, in sum, then we've dealt. In that exchange, we've dealt with the issue of the code and the issue of Judge Potterell. Then we're left with one that should even be shorter than that, which is the rogue unit. We've dealt with the fact that the rogue unit narrative was not invented by you. I think we don't have to go there. But in the J narrative,
just pause. Sorry, Advocate Mkhwebane.
Yes.
Yes, I think I know that, yeah, yes, there was a comment and you then didn't give me an
Oh, yes,
opportunity to.
the question, yes, well, maybe that was
The comment, yes, exactly that. Again, going back to the issue that the comment made in my affidavit, and I think you're linking it to the other matter of Mabuse J as well, the issue of
the
apparently not
proclivity.
listening to and the proclivity and all those.
Ah.
So the main thing here, Chairperson, trying to just present my case or my side of the story is that the investigations conducted by investigators under my guidance, not removing myself from that, using that code. And honestly, when the matter was done, believing that we have the 2007 code, believing that we are using the correct code. And I think when we were defending the matter with the assistance of my legal team, because in each affidavit, I think you've also then now signed several affidavits, Chairperson, and you'll see that in paragraph 2 or 3 of that affidavit, it will say any other thing or which I might not have, or which I've put there. It's at the advice of my legal team. Well, you are fortunate, possibly you've signed few affidavits. I've signed a number of affidavits because you find yourself having to go through affidavits, you have to go through reports, section 7(9) and everything. So I think the main thing is that all that happened, there was no malice, there was no intention to as well behave in a certain way against Judge Potterell. And I think there was an instance where she even used a language which was unbecoming in one of the matters. I lodged the complaint with the JSC, which I never got a response. And even with this one of Judge Jafta, because I was saying to them, I've tried to correct with the rescission, but still continuing, I'm lodging a complaint with the JSC. They've responded, no, we won't entertain that. But again, this forum also helps to those who would want to hear, to those who, well, history has recorded now for the generations to come, because Mina, I believe, Gucci, whatever we do now, it will come back and bite us. Besides the issue of doing to self, to others as you'd want, but the issue is history and our generations to come must learn from these mistakes which we're doing, must learn from how we behave and treat others, and what are we planting in society, because it might have not happen to them who are trying to inflict this pain to me and my family, but it would also happen to their children and their generation. So I think this process is helping so much, and those quotations, they will go down correctly. And I think we are helping H1. I think the evidence leaders as well, they are here to help, not to prosecute, not to judge, but they are here to help the committee. And as well, when they say read this other one, I think it's with the intention of helping, not with the intention of saying, no, she's wrong or prejudging the matter. I think that will help a lot for all of us, because this is a first of its kind. And everyone who's listening, it's recorded accordingly. Yeah.
Yes. No, thank you. Yeah, that's very generous of you. Now, at what I was then saying, and yes, sorry for after that exchange, we didn't give you as a witness the opportunity to respond. But yes, now I was saying then we move to the issue of the fifth ground cited by Justice Bakwa and the others. And I said it had two legs. The first leg we've exhausted about the rogue unit term. I think sufficiently. And incidentally, Mr. van Lochenberg himself, when he wrote a letter to you about the allegedly defamatory use of those words, had attached a speech in which you actually had used the word so-called rogue unit. Yeah. So I think that's that matter is dead and buried there. But the other part of that was the reference which you made in the meeting with the IGI to Monster, where it's also articulated in a strange way, but this is what Judge Prakwa says about it. At 290 Roman 5. The public protector's pandering of the rogue unit narrative and her public reference to the unit as the rogue unit and as a monster, and her stated desire to defeat the monster displays a profound bias towards Minister Kodan and Mr. Pillay. Sorry, and Minister Pillay, it says. I don't know who that is. Minister Pillay and Minister Kodan. So what is being said here now is that let's assume you refer to the rogue unit or whatever it's called as defeating the monster. Then, but now it displays a profound bias, not against the rogue unit, but against Minister Kodan and Minister Pillay, says Judge Pakwa. Now, can you maybe let's do it step by step. That remark, forget about the fact that it was made in a closed meeting with the Inspector General for Intelligence. But what did you seek to convey when you talked about defeating the monster?
The members of the committee listened to the audio. And in that meeting, I communicated with the Inspector General. And actually it was in the exchange of the letters, I requested them to provide the report, and we ended up meeting. I told them that, okay, there is this report, which apparently was conducted by the late Advocate Khatebe. And the report was dropped at the public protector. And we have this report. I'm meeting with you to just check whether indeed there was a report like that. And the intention was to make sure that the intention was.
I think there's some. Is it an alarm? The fire.
I hope it's not happening because of what you're doing here.
Yeah.
Let's
I
just.
think it's the unnecessary heat that was generated by Advocate
no,
Bauer.
there was no heat.
It's the red clothing that brought us.
That's true. I think that's disturbing. So maybe just to pause. I don't think we'll be able to continue. No, there's no fire. There's no fire.
Well, this is Parliament. Yeah. How do we know?
So we'll just pause for a few minutes so that we allow that to stop. Can you please check what's happening for us?
Recording stopped.
Welcome back. Hopefully there won't be another glitch. Apologies, Public Protector, you were on the platform when we paused. You were responding. I hope you still remember what we're on. Over to you, Advocate Mkhwebane.
Yes, the issue of the monster. So it was in that context that we were discussing this IGI report and indicating that I've received it and concerned that such a document can be all over. And I've seen as well, Newsweek has published it. Then we discussed, after that, they explained the legal framework. I think Advocate Gavenda, as we said, we saw her affidavit, and we might as well request that she be called so that she can be cross-examined on some of the things which are not, which are mentioned in her affidavit, which I think we need to put into perspective. So they then informed me about the operations of the SSA and what is happening, houses overseas, the monies which are being used, the recalling of some ambassador because there's allegations that he did, or there's monies which they are using. Then he told me, they told me about their operations and everything. So at the end, she asked the question, so you say the rogue unit or the so-called rogue unit, in fact, she said rogue unit is operating. I said, apparently, and in that context of what they said and the operations of those people who, or there's, and I was even referring to some children who came and complained that they were trained in China, they came back, now they are not deployed properly into wherever they are supposed to be deployed. They were telling me about that. In the context of everything which is happening. And again, the rogueness, it's the operations, Chairperson. It's not about the individuals. Now it's worse, the judges are referring to Mr. Godan and even referring to Mr. Pillay as a minister, which is, I was not referring to the operations. And I think we said it even yesterday when Advocate Mpofu was saying, this now when we deal with what they did outside of the law, and we have evidence to that, and we've showed that if they go to DSO, NPA, listening to and viewing that place, is that within what the interception legislation require? So that was based on that, not on individuals, even Mr. Van Locherenbeck and everyone who worked there, because now the very same thing I've mentioned yesterday, that you've got around 30 to 40 people who are working in that unit, and they were doing their work, much as I would give an example about DA labeling me a spy because I worked at SSA for 3 months. And I've always been saying there are a number of officials who are working there, who are doing great work for the country, and who are in civilian because they are known, they are working there as public servants. So you cannot just label people who are working there or perceive people working there as spies. The issue here is the operations and the activities. It's not about individuals. So I think that is also the issue of monster was mentioned in that context. And as well, the issue of rogue is mentioned in that context. It has nothing to do with individuals, but the action. Thank you.
Thank you.
Thank you. Yeah, thank you, Chair. And maybe I tried yesterday to say I didn't want us to refer back to that audio that was played by the evidence leaders at the beginning to save time. But I'll just refer you to snippets of the transcript of that, just to ask you a few questions on this. And you'll find it at bundle K, item 13. And by the way, in respect of what you've just said now, did the fact that you worked at SSA for 3 months as an analyst make you an SSA operative?
Definitely not.
Well, that's what Judge Bakwa said you were. But anyway, we'll come to that. All right. Now, I was saying in the let's go to 1482, please. And no, further down, the where it says male speaker in this transcript, it's Dr. Dintwe, correct? Throughout the transcript.
Yes. Oh, you okay? Yes, it's Dr. Dintwe
Yes.
who was talking here.
The male speaker, yes, I suppose because you and Advocate Governor were female speakers. All right. Now, if you go further down, please, Tsepo. Yeah. Just want to say, you know, why you should be impeached, but just for what everyone else is doing, which is sometimes you refer to the thing as a rogue unit, other times as a so-called rogue unit. So
Yes.
Advocate Governor says there, but if I could add PP, your idea about, I mean, your inclination that the rogue unit is still operating makes perfect sense, because there's one person that we investigated, which is in the report. We're also investigating her in the special ops. So then it does make as a whatever was running until a unit of 21 people. So it was like, we believe it's a continuation of what went on at SARS. But we have no evidence to prove that it's worse because with the elections and so on. So anyway, two things that come out of that. Firstly, she refers to it as a rogue unit, but also she says in their own view, it's still continuing for whatever.
It makes sense, and there's a unit of 21 people, and yeah.
All right.
They are investigating.
Yeah. Anyway, and then going back to the monster thing, to where you're saying you were referring to the rogue unit itself, so-called rogue unit itself, yeah, rather than Minister Pillay, whoever that is.
But before that, I think if you can scroll up where you speak about it at the end.
On the same page. No, I've got it. I'm saying,
yeah,
I'm going there now. It's paragraph 14, it's page 1490. If you go to 1489, please.
I was referring, Chairperson, I was referring to the context, because it was still a continuation of the
of this discussion. Yes. Yeah. No, that's why I started there about, you were saying when you were finishing, you were now talking generally about the continuation of this and so on. Which part were you referring to specifically?
Can you go back to 23?
Okay.
Yes, because
23.
Yeah, page 23, 1488.
Yes, correct. Okay.
So you see the mails there, Dr. Dintwe. Okay, go back again, Tshepo. Yeah, Tshepo. Yeah, no, 87, 1487, yes. Yeah, so the context, Chairperson, is that they were busy talking about these houses which are being bought, the properties of SSA disappearing, and then the next page, they were speaking about they said officials who were recalled, who were doing allegedly all these things and criminal offenses. And then it's only the president, nobody else. Well, we were talking about the legislation now, what their law is saying and what our law is saying. So it was just deliberations. And then 1488, the next page. Then we were speaking about there's an investigation which the very same 2014. No, go back, Tsapo. Yes. So male speaker says 24. So we shouldn't be dealing with this issue now. To be honest, where there was consequences, they attached so we were, it's just that it's not a good thing, this one. We should be listening to the audio, but just to understand what we were discussing and the context with which we were discussing. Then you can go to the next page where SC wanted, Chairperson, where SC wanted to take me. Yes.
So, yeah, right, yes. And no, it was just a quick thing to say, to deal with your evidence that this was not aimed at individuals, but at the entity.
The operations,
or not at both Minister Kochan and Minister Pillay.
Correct.
Yeah. All right. It says 1489 at the bottom. You say you know all the best in that, but I think irrespective of all that, we need to work together and support each other.
Definitely.
Advocate Governor says thank you. And then you say wherever we can, you know, in our small ways, we will defeat the monster. So let's also not allow things which we think they will threaten us or they'll stifle our work to allow them to be our key focus. How do we make sure that irrespective of what we are moving forward and dealing with it? Because I mean, if we have this monster, because it's another monster, that rogue unit, you cannot have this. And Governor, absolutely. And then, and so on, yeah, all right. So it was not referring to any individual, correct?
It was not referring to an individual, but it was referring to the way it operated, our alleged way it operated.
Yeah,
yes.
Okay. Now, be that as it may, but that's, I'm saying your alleged bias against Minister Kodan and Minister Pillay is supposed to be from that quotation or that discussion. But while we have this, Chair, if I may, again, I'm trying not to spend time on this transcript, but since we've got it, I just want to pick out one or two other small things. Can you go to 1467? Also, just to show, like in the speech that you made, that again, you get cherry picking. Where you say rogue unit, it's magnified. But where you don't, when you say it's so-called rogue unit or whatever, it's not referred to. Yeah.
The alleged as well.
Yeah. So yeah, that's what I'm saying. In this, just read out what you said there when you were introducing the topic to everyone. From in this particular?
In this particular instance, we brought this complaint against the Minister Kodan. I think it was supposed to read, a complaint was brought against Minister Kodan.
Yeah.
It was in relation to the operations of that SARS alleged rogue unit.
Yeah.
We received information that the then Inspector General, the late Ms. Khatebe, investigated this, and the findings were as captured in the report. I must indicate that we received this information.
So just pause the PP. The key thing is that in that particular extract, you refer to it as the alleged rogue unit.
Correct.
Yeah.
SARS alleged rogue unit.
Right. Okay. And then you can read on from. I must indicate because that there's also something else there.
I must indicate that we received the information that the report was conducted, or the investigation was conducted, I think. And the report made several recommendations against the involved parties. Actually, I start where we received information that the then Inspector General, yes. And as the public protector, again, going back to the issue that any organ of state should assist us to investigate, that's section 181. subsection 3 of the Constitution. So we didn't want to rely on the report, which was dropped in our reception area.
Okay, just right there. So and then the charges say that you were concealing the fact that the report was, or rather you said you had never seen the report. Is that congruent with what you say there?
It's not, because they had the audio, they had the transcript. And that's what transpired. I told Dr. Dintwe that the report was dropped at the reception.
Okay, then the next sentence.
I was surprised that whoever had that report shouldn't have had the report, because it's a document which is classified, but unfortunately that report is there.
Okay.
You know, I've seen the report on Newsweek this week. Now the organ of state is supposed to help me. He is informing me to get the report from the minister, though we've also already subpoenaed the minister, yes, because they were saying, no, PP, we cannot. And then they explained the Oversight Act.
Okay, but can you go to 1469? This is now Dr. Dintwe speaking. And if you can just read, because again, it is said that they never confirmed to you that the report A existed, or B was there, and C that it was indeed, it had been finalized on the 31 October 2014, which was the date that was the same as the one in your leaked report. So I'll take to from, I think that ideally, that is in the first paragraph.
Okay, I think that if we are given sufficient time, we will be able to go back and, for instance, write to the president and to the minister to give this time. So they were committing to help me to actually advise them or consult them then that I will be in particular report to yourself, or I will avail the report to, or the particulars of the report to you. So it's not like a complete report. It's one at a time that was given to us. We wouldn't have achieved what we actually wanted to do. I think that ideally it will defeat the purpose why I'll be going to you. No, I refuse to give you the report when we are aware that the report is actually in the public domain. So I think he was telling me that we would want to help you. We are constrained by this Oversight Act because the custodians, okay, still coming to that, actually,
Yes.
Advocate Governor. So I think there he was saying, you know, there's the report. Yes, we know. He never denied that there's a report like that. He acknowledged that the report is there.
Yes, but remember there was now at least two reports which were roaming around. The one that you had, and
Yes.
whoever had it to give to you, as well as the one in the Newsweek, yes.
Yes.
The point is simply whether he said, no, that one is different from the one we have, or when he says the report is actually in the public domain.
Correct. He never denied the content.
Okay, then the next point.
But they are unable to give to yourself, okay, you know, officially.
No, from just.
Oh, there was.
That was not the only issue.
Oh, yes, that was not the only issue.
Maybe if I-
Mkhwebane.
Just as clarity, there is an article in Newsweek. There isn't a report in Newsweek. The Newsweek article reports on the report. Are we talking about the same Newsweek article, Advocate Mpofu? Or is there a Newsweek that has the entire report in it?
Okay, thank you.
Yeah.
Advocate Mpofu.
Yes, there is. When we talk The Newsweek article, anyone who reads the Newsweek article, which quotes the report, I think, I don't know how many hundred paragraphs, word for word, makes it clear that they're quoting from the report. That's what the Dr. Dinto was complaining about, that not only is there this copy, but obviously there's another copy that Newsweek has, which is obvious from the article.
Advocate
Okay.
Mkhwebane, you,
The-
sorry, Judge,
Yes.
through you. You were saying there's a, that's exactly the point. Newsweek had a report. The
Yes.
report wasn't in Newsweek. So nobody knew what the entire contents of the report was that Newsweek had, bar for the paragraphs that was in the article. That's the only clarification.
Oh,
I'm
that's
making.
fine. I'm happy with that, yeah. So
So in the article, there's a reference to the report.
to the report extensively.
Yeah,
So
but you don't have a
No.
full report
No.
in there.
no,
Okay,
no, it doesn't say
thank you.
this is the report of, yeah.
Proceed.
All right. Okay, thank you, Chair. So please read on from, that was not the only issue. So,
That was not the only issue. We also realized that even the complainant, we suspect that they could be in possession of that report,
mm,
but they are unable to give it to yourself,
mm,
officially and all those other things.
mm,
This process you request is more about just legitimizing whatever is in play.
mhm,
Whether we refuse or we give, the report is there.
mm.
There. That's what we are aware of it.
Mm.
But can the advocate just explain quickly our disclosures, provision, and also our difficulty in this particular matter?
Yes. Now, when the, okay, no, let's take then the last point. Go further, much further down, Tsepo.
But I think
Starts
the,
with because, sorry,
Okay.
yes, PP.
the advocate is still confirming
Hmm.
the report, confirming. We were at Edem.
Yeah.
That this is the report, and what is in the Newsweek, it's exactly from the report. And yes.
No, that's what I meant. Remember yesterday I asked you that from that conversation, there's that thing about the good authority and all that.
Exactly.
So here you were talking, there was the minister, there was this is the IGI himself
Exactly.
and the legal representatives,
Mm.
and confirming basically the existence of the report, or that the report you have and Newsweek have
Mm.
is the report.
Yes.
Okay, now,
Sorry, Advocate Mkhwebane. I missed it. I interrupted you earlier on. Sorry, Chair. Can you just tell me on which page it says Newsweek? I missed that. Sorry.
it's
1488, ne?
no, well, the first one is 1467, except that
Yeah.
the transcriber said Newsweek, but we know what they're doing.
Yeah.
It's the first one is 1467. If you go there, please, Tsepo. This is where you say, I was surprised that whoever had the report. Can you read from there? Okay, let me just do it because I'm just answering to Advocate Bao. I was surprised that whoever had that report shouldn't have the report because it's a document which is classified, but unfortunately that report is there. You know, I've seen the report on Newsweek this week. That was the Newsweek. Oh, can you confirm, because you were the one speaking, that you didn't say Newsweek, you said Newsweek.
Exactly. It was
Yeah.
Newsweek, isn't
Yeah,
it? It's a
that's
question
fine.
of, yeah.
Okay. Then you said the other one was on 14.
1488. In fact, where Dr. Dintwe was also confirming that the report is there and actually it's there. Well, 1488 we were talking about.
Earlier on. Okay, anyway, I think one is enough. My
Okay,
colleague
so
had
yeah,
sent-
where I was reading now, it was where Dr. Dintwe was confirming that possibly even the complainant has it.
Yes.
Yes.
All right, then the last of those where basically they confirm the or rather the where you're saying you are ad idem, where you're basically talking about the same thing as it were.
Yes.
1469.
Advocate Bauer, if you can switch off your mic.
Right. And you confirmed yesterday that the report that you had indicated that it was issued on the 31st October 2014.
Yes, I think
Yeah.
it was dated that date.
Yeah, well, we've got it in the documents here.
Mm.
But anyway, just read what they say then from because only dealing.
Where, which page?
Advocate Governor at the bottom. Yeah, there.
Or because only dealing in the special ops of SSA would not have actually addressed the terms of reference given to us by the Minister of State Security. But we finalized the report on the 31st of October 2014.
Yes. Okay.
Yes.
Now, if they confirm this date and it coincided with the date on the report that you had, what would that be confirming that you are talking about the same report?
Definitely, we're talking about the same report. And another thing interesting is that the very same advocate Governor has been with that institution for a long time. And maybe when she comes here, she'll also have to confirm whether, because here she confirms that she was the one who, because it says, because only dealing in the special ops of SSA would not have actually addressed the terms of reference given to us by Minister of State Security, because it was the then Minister of State Security who requested this investigation. But we finalized the report on the 31st of October. So the date is the same. Maybe she can also then indicate whether was she still working there, because I never asked her.
Yes. Anyway, I think it's clear.
Yes,
now.
and
Sorry.
I think the issue of we qualified that the report and made it clear that at the outset that we did not have a mandate over SARS, which they explained. But then the only thing was that the referral was referring to the intelligence and encroaching on the mandate of SSA.
Okay. And then as I'm saying to save time, I think it's all out there now, but just for the sake of completion, can you go to 1475? And just a short sentence, go further down, start with because as well, okay? Yeah, just the first sentence, what did that communicate to you? Because like we said.
Okay, oh, you must tell me it's because I see another because at the end. Because like we said, the report is out there already.
Yeah. So
Yes.
what did that communicate to you about the report that you had?
Still confirming that it's the same report.
Anyway, and do you regard Dr. Dintwe, the Inspector General of Intelligence, as good authority?
Definitely, he is good authority. And I think what needs to be understood, Chairperson, was that moving away or with the principle of relying on government, because the public protector, when we investigate, you remember I said to you, because of that submission, which is signed by SARS, for us is a credible information. The meeting I had with Dr. Dintwe is a credible, good authority. Meeting I had with the two ministers of state security, to me, are good authority. I can't say Noseweek is a good authority. because yes, they published it, and on confirming this, then it means that the very same report I'm having, indeed, Newsweek published a good report or the exact report. What I'm saying here is that I wouldn't just rely on Newsweek and say I've got the findings. That's not what we do. We can't rely on newspapers and regard them as gospel truth. I think that's what we normally do, and hence I also called upon magistrates, judges. Well, we're still going to address the issue of Sunday Times, but just let's listen to the document, official documents.
Okay, thank you. Thank you, Pipi. Advocate Mbofu.
Thank you, Chair. All right, so that then deals with number 5 of the number 5 in the list. I think for us it's number 6 or 7 of the 9 issues. Then, as you said, then the next one is the Sunday Times. I mean, I think the less said about this one, the better. But apparently, number 6 on their list, on the list of Bakwache judgment, is that you were biased because, quote, the public protectors complete disregard of the Sunday Times apology and Crown apology. I can please I don't think we need to waste much time on this, but are you inspired by whatever the Sunday Times does? Or, I mean, was the investigation in the first place inspired by the Sunday Times?
I think on this, Chairperson, it's disappointing indeed to be blamed for this Sunday Times apology. And again, I've said it several times that Sunday Times, News 24, Daily Maverick, they might publish things, and the way they publish information, it's what they publish because they want what is selling, or they sell. They are in the business of making money. I mean, even currently they are reporting about this process, and now they are alleging I'm attacking judges. So I think for judges, any officer of the court, any legal practitioner, just read these papers with a pinch of salt, because normally how they operate is that they will, when they publish their stories, and to any member of the public who's listening, they'll send you questions. They will then, they have this source or information. Definitely, some will conduct investigation. Indeed, you find that the investigation they are publishing, it's information which is there. And hence I said earlier that using them as leads helps, because you follow the story and then you go deeper, you go to the evidence, you request the department to respond, you have their policies, their documentation. But now to be blamed that I never took that into, or I disregarded that information. In the first place, I don't read Sunday Times. My investigators possibly were investigating, they never maybe even saw this article, but their main issue was that, I think Mr. Mataboge even mentioned that normally he will stay away from information. He would want to have his own source of information, which is that investigative mind to say, yes, I see this. Well, we operate differently. Each person has their own way of investigating. But normally I would encourage them, yes, you can see that what's happening around you, current affairs, then you go and investigate and use it as a lead. So it was purely that, but it's unfair to be accused, Uguti, I disregarded the apology of the Sunday Times. Sunday Times is not an investigator. Sunday Times doesn't issue reports. Sunday Times, since I said, is in the business of making money. And unfortunately, when it comes to me, again, I'm still repeating, mainstream media has never been fair to me, and they will always perpetuate a narration and manufacture consent, which will always push the narrative that I'm this incompetent person, or I'm this person who doesn't know my work, or I can't do my work. And I said it, they are a key stakeholder. I'm not neglecting them. They are a key stakeholder. Hence, I have the spokesperson, I have the communications section who will work with them, and they can do a lot if they can just change the way they are reporting. Because if they help us, firstly, publish our reports, what impact can our reports do to the public, and all those, and not just focus on individuals. But Sunday Times, unfortunately, I differ with the judges to just rely on them and blame me for disregarding their apology. And Judge Kroon also, I never saw that, because we were concentrating on our investigation. Judge Kroon might have apologized, and on his own as well, they were working as a panel, but he decided to do that. And I think we can unpack what he was apologizing for. What does that have anything to do with us, the evidence that people's communication was intercepted, or the fact that the viewing of DSO offices, was it done properly?
Yeah. No,
Yeah.
well, I can assist you in that. I'm sure it's common cause. But the only thing that Judge Kroon apologized for alone, as it were, was that what he said was reliance on the Skakane report without, as it were, examining it independently. So that's in essence what he apologized for. And so it goes back to the question of whether the Skakane report was discredited or not, which we will wait and see who discredited it. At least on our version, we're not aware of any such allocation.
Yes.
But so if let's assume that if the Skakane report was widely discredited, then of course the Kroon apology can be added to that. Yeah. But that's an issue that will be argued between us and the evidence leaders. Yeah. As I said yesterday, as I understand your version, at least, is that the idea that the Skakane report was widely discredited is itself manufactured. It's not, I mean, unless if something else will be presented to us.
Yes, and I think what I will also request, I spoke about that, Chairperson, yesterday, that if judges can just read our reports and understand how we investigate and how we regard as evidence, and what we say, the application of the law to the evidence before us.
Yes.
Because I cannot have a report which will just put all the information about the matter. Sunday Times said this, Daily Maverick said this, IOL said this, and this person said this. So I think that's how we do our work. And again, in the spirit of just focusing on our mandate, but not perpetuating or being in the business of just giving papers authority, like regard papers as authority. They are not authority.
All right. Okay, just to get that out of the way then, so that we move to the next one. All right. In your view, put aside the fact that we established that the Nugent commission actually agreed with you regarding the breaches of procurement and other. Let's assume the Nugent report, quote unquote, discredited Skakane report. As far as both of those would be independent reports by independent panels of different people, and at least the Skakane report was made up of 3 advocates, if I remember well. Would you, from your point of view, would you have ranked one of those reports above the other? In other words, what's the difference? What makes Nugent better than Skakane? That the one, if the one differs with the other, then we must listen to the other one.
Mhlambe asiyeni-ke, instead of also speaking about maybe, let's say, Judge Nugent, Judge Kroon as well.
No, sorry, okay, no. Okay,
Yes,
carry on,
I just
carry on.
want to say,
Bearing in mind that they were not performing judicial functions, they were just
Nkuti, the
heading,
fact of the matter is they were there as commissioners,
right.
chairing that commission. But further, all of them are legally qualified. All of them are in the administration of justice. So I think it's so wrong to just, again, perpetuating that narration. You know, Chairperson, I would want to say to you, maybe let me say it, which is the fact. As a public protector, I acknowledge that I operate in a political space. I acknowledge that I'm a Black person. I acknowledge that anything I do it intentionally to make sure we don't repeat the atrocities of apartheid. So now, if we pick up a lot of these Abu Sunday Times, judges perpetuating the very same divisive ways, when it's a white person or when it's another race, then we are treated differently. Because the thing is, Judge, advocates Skakane and team yake, they are also legally qualified. They did their work the best they know how. But now I prefer to use Commissioner Nugent or Judge Kroon. So it's that thing again, you promote, people must always think when it's said by Sunday Times, when it's said by 702 or ENCA, it's the truth. So we need to change that. Well, going forward, can you please consider that as the leading party, which still has that majority to deal with issues which can remove these systemic issues which are still there, which we still, it's there, but sometimes we can't touch, but it's subtly done. And we are used to perpetuate it. Because the fact of the matter is, Skakane did the best he knows. And Wes, he was requested by the very same Mr. Pillay to do the work, and he was paid for that work. But now you perpetuate this narration, you then synchronize. And so I think it's so wrong. I will plead with members of the committee and everyone. I mean, even this motion lodged by the DA, which is good, and at least let's engage at that level openly. Why do we have to continuously perpetuate such things? And why some of the people who allow themselves to be used as well to pin down and discredit people, which is not correct?
Yes. Okay. Can you think of any other difference between Skakane and Nugent?
No, none, because both of them were requested by the Commissioner of SARS.
All right.
Who established the commission? Yaga Nugent. SARS requested. Who requested Skakane to investigate, and his team is SARS. So I think let's not perpetuate that. And
Yes.
I think let's, as leaders and as people who can make changes in wherever we operate,
Yes.
including judges, let's ensure that we are intentional in changing the mindset to when it comes to a different race, Therefore, it needs to be believed, or when it's reported by Sunday Times, it must be believed.
Yes, and you then are supposed to be impeached because you used the Skakana report, despite it having been widely discredited by Judge Nugent. I suppose that they were widely is just because it's Judge Nugent. And the comment, I think we read it, I won't go there again. I think in Judge Nugent's defense, all he said was that why it has been found to be unlawful is not clear to me, to him. And that is seen as wide discrediting of reams of pages of hard work by Skakane and his panel. But anyway.
I mean, to be also fair to Judge Nugent, he said, I've mentioned it yesterday, Chairperson, okay, they might have done it covertly, they might have done this, but they must do it within limits. So I think it shouldn't be just blown out of proportion and yeah.
All right. Okay, so that does number 6. The next one then is the Gupta issue. We dealt with that. And then Potterell we've dealt with. Let me just double check that if we are where we wanted to be. There's one more, YouTube. Judge Pakwa now goes further to say that in number 2, the manner in which the public protector interacted with Minister Kodan during the investigation and releasing the report. Not only did the public protector elect not to engage with Minister Kodan's attorneys on record.
What paragraph is that?
It's still 290. That's where the 9 issues are.
Okay.
But now this one is Roman 2, PP.
Okay.
Yes. Remember, Roman 1 is jurisdiction. Roman 2 says the manner in which I've just read it out. Not only did the public protector elect not to engage with Minister Kodan's attorneys, notice was publicly, but I'm sorry, the Section 7(9) notice was publicly posted on YouTube before giving any notice to him and his attorneys. Similarly, the report was presented to the media without any prior notice to Minister Kodan nor his legal representatives. Well, so Judge Pakwa is basically saying you posted the Section 7(9) notice on YouTube. You remember you said that one of the reasons why you stopped including remedial action in Section 7(9) notices was because they were being leaked.
Correct.
Okay, so I think Judge Pakwa is right here. Now there's a very person who does that, then goes to release the Section 7(9) notice on YouTube. So you're doing even a bigger leak yourself. Did that happen?
Definitely not. And Chairperson, I will ask, I think that YouTube was played here, or was it not?
It was before, but we can do it again. But it's not long.
Because I think it's so wrong to be blamed that I issued a Section 7(9) report publicly. That has never happened. And Chairperson, when I investigated this matter, I was under such a lot of pressure and stress and, attack by the media. That I would have to say. And there was a stage, whilst you're telling Tseho to Tepo to find the...
Yes.
There was a stage, yes. There was a stage when...
Bundle H, PP folder item 31.7.16. Okay, you can continue, PP.
Chairperson, there was a stage even when I requested legal services. Maybe I must just check that. I said to them, let them even report the attorney of Mr. Kodan to Law Society, because anything we write to them it was just published. It will stop.
Let's just pause.
I think
just
Ms.
pause
Bauer is
quickly.
trying to bring something to my attention.
Yeah, I'm just saying we've already played the clip. Advocate Pof. It's already on the record.
Yeah, well, we want to play it again. Because it was played for a different purpose. Unless if you are prepared to accept that this is false, that she elected, what to say? That the public protector
Elect not to engage with Mr. Gordhan, attorneys on record,
and notice
was
that the section 79 notice was publicly posted on YouTube before giving any notice to Mr. Gordhan and his attorneys. If you are prepared to accept that is false, then we don't have to play the.
Yeah, the clip's on the record. The clip says what it says. I don't have to accept anything. The clip is what it is.
That's fine. Thanks, Advocate. Just before I come back to you, because on this issue, I can't remember the name of the witness who was tested on this and would have responded, but I will allow it because it's Advocate Mkhwebane is now in her own right responding to the issue. I can't remember how long the clip is.
It's not. It's about 4-5 minutes.
I think for completion, let's do that.
Yes,
It's
fine.
Chairperson.
Thank you. Okay, let's bundle H PP folder item 31.7.16.
And I think, yes, it was played by that witness because they were trying to show what I said about the rogue unit. So I want it to be played to show the members of the committee, the chairperson, the public, that I never issued a section 79. And chairperson, I was still saying that attorney of Mr. Gordhan, Mr. Malach, was doing interviews for ENCA, for 702. Anything we write to them, it was published, anything we write. So this was a way of directly communicating to the public, those who cared to listen to me, because they had the support of the mainstream media, because whatever they report goes, and what I say, it's not reported. So I had to then use the platform of direct communication to inform the public that I will be issuing the section 79. And I think for the record, it needs to be played so that you can see that I was informing the public, not issuing.
That's fine. I have rolled that on
Thank you.
already. So can we play it? And
Yes,
then we
if it's
conclude?
ready. And Chair, again, they say you must don't look gift horse in the mouth, because you've already ruled. So we're not busy convincing you for something that you've already ruled. But I think the point that's being made is that it was, and now I've remembered, the witness was Mr. Van Lochenberg, that it was played for a different purpose, which was to show that when she was talking, she said rogue unit and not so-called or whatever. But now it's for a different purpose of actually dealing with a much more serious matter.
If I understand well, it was a press conference, press release issue, not even a speech.
Yes.
It was not in a speech.
Yes.
If that's the one.
It was not. Yes, that's correct. Yeah. And now it's a different purpose of showing that the section 79 notice was never publicly posted on YouTube, as it says in this judgment.
Do you have it, Stephen? Okay.
I would like to communicate with the South African public about what has been happening in our investigation of the Minister of Public Enterprises. And there were allegations that I'm harassing him, and we issued a subpoena to him requesting information about several investigations which we were conducting. The first one was relating to the pension payout to Mr. Pillay, and he was subpoenaed, he appeared, and that was the complaint which was lodged in 2016. And we wanted his side of the story because we've conducted our own investigation, and as well to help us in the investigation. Normally that's what I do with all other ministers in my investigations, or in all other people complained against. So in this one, then it was all over the media and being portrayed as if I am targeting Minister Kodan. And secondly, there was also a complaint which was lodged in 2016 relating to the tender processes or irregular tender processes of a contract which was awarded to BBND, and also a tender relating to or the purchasing of Interfront. That investigation is in progress, but again the EFF lodged a complaint plus an anonymous complainant, where they were also lodging a complaint about the involvement of Minister Kodan. It needs to be clear to the South Africans that I receive complaints. I don't go around and ask people to complain. And therefore, when I receive the complaints, I will have to approach the person who's complained against, request their side of the story. And we will all know that the EFF complaint was dealing with the rogue unit, the processes which have been followed, the recruitment, the procurement of the equipments, their operations. And another complaint was relating to the complaint under the Executive Members Ethics Act, where they were alleging that Minister Kodan lied in Parliament about his meetings with the Guptas. Therefore, I'm coming forward to say there's still a number of interactions which we'll have with Minister Kodan. There's also another complaint about IFMS at Treasury and under Minister Kodan's watch. And again, we will still go back to him and request information. Now, the challenge I'm facing is that the report we've recently issued, there was a serious attack on the person of the Public Protector. And this media narrative, which I've indicated that I don't own any form of media. So this is my opportunity to communicate to whoever will listen that I'll be issuing a Section 79 notice relating to the EMIA, which I need to finalize within 30 days, which that time has actually lapsed, relating to his meeting with the Guptas. But that is also the part of that Section 79 notice is issues relating to the operations of the rogue unit. And I know that one will be faced with a lot of questions. In fact, there will be a lot of questions. There will be allegations that I'm also still persecuting Minister Kodan, but I'm doing my work. And I understand when it comes to the issue of the rogue unit, people have lost lives, people have been tainted. And I think that it's still going to happen, but I'm doing my work, and I will be serving that notice today, which is the 2nd of June, 2019. In fact, it's the 3rd of June, 2019. And I'm ready to receive all the backlash, but I'm doing the work. I am not targeting or harassing any minister, or specifically Minister Kodan.
Thank you very much. On a lighter note, you said you're ready to face the backlash, and you're facing it now. And but the question really is whether that what you are prepared to face included 3 judges saying that what you've just done amounted to posting the YouTube, the section 7.9 notice on YouTube before giving it to Mr. Mkhwebane?
Definitely, and that's the backlash I've been receiving, and as well, it was blown out of proportion. Legal analysts and some analysts were even called during that process. I was even attacked and, labeled names. Now this as well, it's part of the judgment. And if it says I issued, I was just informing the public that I will be issuing the section 7.9, and in that section 7.9, it deals with EMIA and the other parts and of the rogue unit.
Yeah.
And it was also dealing with or indicating that there are other investigations. I received complaints. I was not targeting Mr. Mkhwebane. I'm not targeting him. It was complaints which we were investigating. So if I was issuing a report, a section 7.9, I would have read it like what we did with the common cause issues, issues in dispute, the evidence, the finding, and issue it like that.
Yes. Okay. Maybe to be fair to Justice Bakwa and his colleagues, the word they used was public. You publicly posted on YouTube. Well, I don't even know if that's technically possible, but that you publicly posted on YouTube the section 7.9 before giving any notice to him on his attorneys.
I didn't publish the section 7.9 firstly. Secondly, by that YouTube, I was informing everyone that I will be sending the section 7.9 so that I don't see the interviews again all over when I send that section 7.9. Because again, the section 7.9, when we issue it, Chairperson, normally we would want to make sure that it's not shared, because in each and every section 7.9, we will indicate that this is just for the eyes or for, yes, it's only for the person or people who are implicated, so that we don't compromise the investigation. And as well, it's still not a final report. So that's what we do. Then the issue of the, I don't know, you're still coming to the issue of the report.
Sorry?
I don't know whether similarly the report was presented to the media without any prior notice to Mr. Mkhwebane.
Yes, that's what the judge said. Similarly, the report was presented to the media without any prior notice to the minister. Did that happen?
That notice was never done, it's not done. I was not doing it with any other person who is implicated, other ministers, presidents, other very important people. Because when we issue reports, we only announce that we'll be publishing reports. And then that's what the law allows us to do. And then we I publish the reports through media briefing, and then we post it in our website, especially reports. And then the investigators who are investigating the matters will then share the reports. I must indicate, Chairperson, that we were trying to make sure that also on the day of the publication in the morning, whilst issuing the statement, then they are finalized, they are sending the reports directly to those individuals.
Yeah.
So we were trying to manage as well the issue of, the report now it's all over without the person who was investigated receiving the report. So on this one, we might not have shared it. Notice was not given, and we might not have shared it quicker than what we expected.
Okay, now, to your knowledge, as you've said, whether it was the president or the king, do you give notice to people before you issue the
No,
report?
I was not doing that. I
Okay.
never did that before.
And yes, well, you might not have done to the president or the king, but Mr. Mkhwebane, I understand, is above those levels. But do you think, have you ever heard of any of your predecessors, whether any of your predecessors has ever given notice before releasing reports?
I don't know. I have never seen that in the handover report of my predecessor.
All right.
And it was not done maliciously. It was just making sure that we have control of the process, and that's all. Not to say, yes, courtesy, maybe we should be doing that if,
Yes, but if you
Yeah.
do it, you hopefully you'll do it for everyone,
exactly.
not Mr. Mkhwebane
Oh, yes, definitely.
or any minister or,
Mm.
all right. Okay,
Any public servant, yes.
public servant or prime minister.
Mm.
Okay. Now, if we go to then chair, we can go to the qualification issue. And Chair, thank you for allowing me to take this detour. But we're now at the place that I was talking about, Chair, where we've covered the 5 of the 6 and 8 of the 9. So on both lists, the only issue outstanding is the qualification issue. So we'll deal with it in one go.
We'll just have a 4 minutes stretch and back at 12:30, and then we'll continue.
Just 5 minutes stretch. Thank you, Chair.
There's KPMG,
Said 4, yeah.
which we
adding it.
never dealt with, or I don't know.
Thank you. Stretched.
Yes,
PP.
thank you, thank you.
Then we'll come to
Recording stopped.
back. Welcome back, colleagues. We're going to take a quick session towards lunch. Over to you, Advocate Mpofu.
Thank you, Chairperson. Yes, no. PP, I think, yes, we have covered all the 8 things except the qualification. I heard you saying we didn't cover KPMG.
Also, it's part of the reports. Okay.
No, it's not only is it part of the reports, just to save time of the committee, I think we'll deal with that in legal argument, because you remember Mr. Van Lochenbeck, when I cross-examined him, considered that the KPMG so-called retraction was not a complete retraction. You'll remember that, Chair. And he even considered that he himself had complained, I think, in the media, that they did not retract the entire report. So I think we'll just refer the committee to that evidence, which showed that the only thing really that KPMG retracted was that they had taken the view of legal experts and presented it as their own view on the question of whether Mr. Mkhwebane was aware of the rogue activities of the something like that. But anyway, the point is that I don't think we need to recanvass that.
Okay.
So if we then go to the qualifications issue, and that would be, I think it's page 93, Chairperson, of the okay. Can I do this? I'm sorry, Chair, to do this, but it also hopefully will save us time. So as far as the judgment is concerned,
Yes, you continue. You said 93.
93, yes.
Page 93.
Yeah, of the report. Sorry, I was just guessing. Let me just check if that is.
Oh, it's true.
I was just doing that from memory. Oh,
PP says it's true.
oh, it is. Well,
Yes.
okay.
Good.
Good.
Example.
Good guess. All right. Yes, it is 93. Thank you. Okay. Which is, yes, it's page 93, which is paragraph 5.6 of the report. And Chair, what I was saying, we don't even have to go there. But as far as the judgment is concerned, it's issue number 9. And it's articulated as follows in the judgment, paragraph 290, as one of the bases for her alleged bias. The public protector's relentless pandering of the untruths of Mr. Pilay's qualification. That's the reason why she's biased. Her relentless pandering of the untruths of Mr. Pilay's qualification. That's how the judge is articulated. And Chair, I know you're going to think that I'm avoiding this qualifications issue. Every time there's something on its way, but it's all meant to save time. Just as a reference point, Chair, it's I just want to take you to the independent panel's report. And this should take less than a minute. At paragraph 232 thereof, we'll come back to that page 93. Maybe let me speak to it while she's looking, Chair. The point I simply want to make here is to show that the 9 issues that were identified in the judgment are the same 9 issues that were identified by the independent panel as so-called prima facie evidence of incompetence here. So to the extent that those 9 issues are baseless in respect of what we've gone through since yesterday, they will be equally baseless as grounds for the charge. That's paragraph 232.
Paragraph 232 of the report or of the,
Yes, of the IPR, of the independent panel's report. Yeah,
okay.
sorry. No, sorry, I just actually went where it's, it's go to
232 here.
33. 232 is where it's actually a mirror image, 233, the misconduct, because the incompetence is kind of half of the misconduct. So let's take the bigger one here. So there, Chair, you'll see that it says, we now being the independent panel report, find prima facie evidence of misconduct in the nature of an intentional and gross negligent failure to meet the standard of behavior or conduct expected of a holder of public office. Sorry, no, that's the CR17 one. Okay, no, it's not. Actually, this is a misprint. They wanted to say, I remember.
Just cut and paste, they repeated.
Yes, they just repeated. In fact, for all the members
as well.
Yes, you did. I think for all the members, we should just change that now manually, those who can. Say in this where it says in respect of CR17, it should say in respect of the
Mkhwebane Pillay Rock unit issue.
yes.
That's my notes.
But that's what yes. For the following reasons, yes. Okay. So I was also getting confused now. So it's for this report that we're discussing. And then it says the 9 aspects justifying the finding of bias against Mkhwebane and Pillay listed at paragraph 290 of the full court judgment, which are in summary, and then they are listed. So just so that members know that the 9 issues that we have been dealing with are the same 9 issues that were referred to in this. And then the rest is just repetition of the issues that we've dealt with, the YouTube and all sorts of things like that. And 233.1.9, which is where we're going now, is the PP's relentless pandering of the untruths of Pillay's qualification. Right. Okay. And finally, we get to the qualifications issue. Okay. Temple page 93. Right. Okay. PP, I think, after all the expectations on this issue, it also should not take us much long because it was also dealt with by Ms. Mkhwebane, I think. Let's just cut to the chase. The allegation here is that you are the originator of the false notion that Mr. Pillay does not have a degree and also was not in possession of a matric certificate. First of all, does Mr. Pillay have a degree?
No.
And did he ever present to you, or did you ever have any sign that he was in possession of a matric certificate?
According to the investigators, his file was empty SR, so we don't have that.
Yeah. And okay, in fact, that's seems to be already half of the answer, yeah, because it would seem that it's SARS, rather, not even your investigators, let alone you, who came up with this. Can you go to 5.6.4?
Of the report, yes.
Yeah.
SARS, in their response dated 5 February 2019, did not dispute that Mr. Pillay did not have a degree and that he did not possess a matric certificate.
Right.
So, and here, Chairperson, what we were investigating, just to be clear, because the issue of matric was the one which was magnified out there. It's the qualification, the necessary qualification for the position. So yes, we were looking into that. That's the issue we investigated.
Yes. Yes. No, we dealt with that with Ms. Mkhwebane, that I think there seems to be either a deliberate or an inadvertent, to quote the phrase, deviation of the issue to this matric thing, which is just a red herring. But the purpose, maybe now that you've said that, let's go back to page 93 and read out really what is the heading of that of that qualifications issue.
Yes. Regarding whether Mr. Pillay was appointed to the position of Deputy SARS Commissioner and subsequently as SARS Commissioner, whilst he did not possess the necessary qualifications for the position, and if so, whether such conduct amounts to maladministration. Maybe I must also indicate that if you go up there where we speak about the complaint which was lodged, it was also speaking about the qualification of Mr. Pillay.
All right. Nothing about matric or PhD or whatever.
It was, we were looking into the qualifications.
Whether he qualified to be a commissioner of, rather a deputy commissioner of SARS, and I think at some stage even an acting commissioner.
Yes.
And that sentiment, if you go to your common cause issues, I think it also comes out, particularly at 5.6.3, but let's start at 5.6.1.
It is not in dispute that Mr. Pillay was appointed to the position of Deputy Commissioner by SARS in April 2009.
Right, 2.
Then 2, it is also not in dispute that at some stage he also acted in the position of a Commissioner of SARS.
And 3,
the issue of my determination is whether Mr. Pillay was appointed to these positions whilst not in possession of the necessary qualifications. That's what we were determining here.
Yeah.
So hence then we go to the issues in dispute, because I remember, Chairperson, I said we then bring the complaint, we write to the said department, we then inform them about the complaint, and then we will request several documents from them. So then they responded to our letter. So hence here we are detailing, or the investigator, because they are the ones who receive the responses and they must analyze the evidence. They are detailing what information we have.
Yes. And now the issue was turned into the fact that Mr. Pillay, I think when you were interviewing him, claimed that he had matriculated in 1970 in Benoni or whatever it is. But did he ever produce, or did SARS ever show that he was in possession of a matric certificate?
Hence, I'm saying that that's what the investigator said. The response we received from SARS, they did not dispute that Mr. Pillay did not have a degree and that he did not possess a matric certificate. Chairperson, let me say this. Again, there's that issue of mixing up the investigations.
Oh.
When I met with Mr. Pillay, it was regarding his issue of a pension. It was, I think you can help me through Chairperson SC. Let's deal with the date on which the Pillay matter was investigated and the date. And then let's go and deal with the date on which we received this complaint and dealt with it, because Chair, it will show you that that question was asked during the meeting for the Pillay investigation.
Yes.
Not for this particular matter.
All right. No, that's a useful comparison. If you go to the Pillay judgment, which is just before this one, this before the rogue unit one, I think, in the judgment's file. Yeah. Okay. Just for while Tsapo's looking for it, this one, the rogue unit complaint of Mr. Shivambu and another person was I think we established was in 2018, I think, if my memory serves me well.
The Pillay pension was lodged anonymously on the 18th of November, 2016.
Yes, no,
Yeah.
We're going there. I'm saying the one of Shivambu in terms of 4219 is 12 October 2018.
Okay.
Okay,
Yes.
so let's keep, no, sorry. That's the unanimous one, 2018. The Mr. Shivambu's one was 9 November 2018. We established that, I think, 2 days ago. Okay, so we keep that date in mind. And then the Chair, we don't even have to display this unless if it's disputed. It's on the first paragraph of the Pillay judgment. It says the report is a culmination of an investigation conducted by the public protector on the strength of a complaint made anonymously on 18 November 2016.
Yes.
So I think that the point we're simply making now is that these reports, these were far apart, and whatever interview happened. So the point I'm making, PP, is that in relation to the rogue unit investigation, you did not have a face-to-face meeting with Mr. Pillay.
No, I didn't, and with Mr. Kodan as well, I didn't.
Even with Mr. Kodan.
The only meeting was on the Pillay investigation,
Which was a 2-year investigation of 2016.
Yes.
Okay. So
and
now,
I think with that also, maybe we should be checking when was that interview with Mr. Pillay and Mr. Kodan.
No, I don't even think that would be necessary. I think the point is sufficiently made by the fact that whatever discussion you had about his matric was in relation to a different investigation.
And a different investigator, Chairperson.
And even a different investigator.
The investigator was not Ms. Mkhwebane. The investigator was Mr. Njabulo.
Okay.
Njabulo.
Yes, I think Mr. Mkhwebane told us about Njabulo. I also forgot his surname. Okay, fine. So Ms. Mkhwebane could not even, yes, if it was the same investigator, she might have even remembered, even though it was a different investigation, that there was this issue of the matric certificate.
Correctly.
And
So I think that that context is very critical as
no,
well.
no, it is. And the only reason that it was raised in the Pillay context is because in that, again, there was a suggestion, at least, that his so-called retirement had been approved by Mr. Kodan because of their friendship and struggle connections and so on.
Correct.
Okay. All right, good. Okay, so now I think that, well, quite frankly, that it should end there, that this was about a different report, and number two, that it was SARS that said they couldn't find his certificate and not you.
Yes.
But I suppose we just have to, for the sake of completion, to make sure the members are with us on this, we will just deal with one or two more aspects of this, which is now trumpeted as a ground for your alleged bias or targeting Mr. Kodan or Mr. Pillay, I don't know.
So we in our investigation also we requested an affidavit from Mr. Mkhwebane. So it's paragraph 5.6.5 where
5.6.5 around this metric issue.
Around the qualification
qualifications,
issue and how they operated in SARS.
Okay,
So
but where
then
they
he-
said, yes. Okay, in other words, 5.6.4 says SARS confirmed that he doesn't have a degree or a matric, but you didn't stop there. You also went to Mr. Mkhwebane, who was then the CEO, I think.
COO
commissioner.
of corporate
Yeah.
services and then at the commission.
Right. Okay, take us there, 5.6.5.
Yes, so that's what he referred to the during an interview with Mr. Mkhwebane on the 25th of March 2019. He referred to the leadership competency model review accompanied by what is termed the goodness of fit conducted by SARS during the year 2008, which confirmed that the value that Mr. Pillay brought to SARS, hence the desire to retain his employment at SARS as Deputy Commissioner on a contractual basis following his retirement. So then Mr. Mkhwebane further indicated that goodness of fit assessment was conducted by Hay Group on Mr. Pillay and 5 other SARS EXCO members to determine their succession fit for the position of SARS Commissioner. So the EXCO members, which I think was we needed to make a correction there, who were assessed in terms of the goodness of fit were Mr. Mkhwebane, Beriho, Edward Kisveta, Kosilo, and Jean Ravel. So that was their plan in 2008 already, that this is how their succession planning was going to be. So they relied on that. So Mr. Pillay is said to have been one who came out as a highly ranked of all the 6 EXCO members assessed in terms of most of the leadership competencies under the SARS leadership model. So they had that leadership model more than not focusing on qualifications, because this leadership model, I think it was checking competencies on their expertise and qualification and all those. So he says, according to Mr. Mkhwebane, despite not being in possession of a degree, Mr. Pillay fully met the requirements for the position of the SARS Commissioner. So again, Mr. Mkhwebane confirmed that Mr. Pillay didn't have a degree, which is a qualification. So in his response, Minister Kodan stated in an affidavit that, because then we requested an affidavit from Mr. Kodan, there is no formal qualification required for the appointment as Deputy Commissioner. Mr. Pillay proved himself amply qualified for the position by his dedicated and successful service to SARS over the years. Mr. Pillay joined the public service in January 1995 and served SARS for more than a decade. For the majority of his tenure at SARS, he had held various senior positions and discharged the accompanying responsibility of such high-level positions in a commendable manner. Mr. Pillay had always excelled at his job and made a significant contribution towards the establishment of SARS, including building and refining its enforcement and investigative capability, as well as the establishment of the SARS Large Business Center. These improvements to operational efficiency made SARS the highly respected organization it was until September 2014. His knowledge and experience and his leadership as a deputy commissioner were invaluable assets to the institution. So even here, Mr. Kodan is confirming that according to him, no formal qualification is required for the appointment. So the issue here, Chairperson, we were looking at is the qualification. So Mr. Makashula confirming to SARS, we'll have to check that letter of February. And that's the information which was before the investigator. Mr. Makashula confirming, Mr. Kodan confirming that Mr. Pillay didn't have the formal qualification.
Yes. And your understanding of a formal matric is a formal qualification, isn't it?
Exactly, because I mean, that's how South Africa, well, that's how public service is structured. All of us, I mean, that position is a very high position for one not to have that. And I don't think it will be fair to others not to, well, we have a lot of people who even don't have matric or who have matric, who have masters, who have degrees, who have doctorates and experience. So that was what we were investigating. We were not checking whether the person, the experience, because indeed other institutions in their policy, they incorporate that even if you don't have the post-matric qualification or the qualification, but your policy allows that you, because of your experience and everything.
Okay. Anyway, I think that's the nub of the issue.
Yes.
Did SARS provide you with a policy that allowed for someone with a matric, let's say, only to rise up to the level of a commissioner of SARS or deputy commissioner of SARS?
There was no policy. The only thing we got was that goodness of it, which is not a policy. We needed a policy, maybe which would say that irrespective of the qualifications, we can appoint any person based on their experience.
Yes.
And further, the worst part is that the response by SARS, which we will go through, where 5.6.10, yes, they were saying it was approved by cabinet, and therefore SARS did not have any records of Mr. Pillay being appointed commissioner for SARS. So this one, it was relating to the commissioner, well, of which he was acting. But the issue here we will still go through was that the investigators were saying in the file, they couldn't find any information.
All right. No, that's fine. And I'm sorry, Chair, if I seem to be almost asking the same question, but in a different way, but it's for the sake of emphasis. Let's say, irrespective of what you believe as a person as to whether someone with a matric can be a commissioner for SARS, let's say that there was indeed a policy that said, whether you have a matric or not, if you have sufficient experience, you can rise up to any level. Would that have, from the point of view of public protector, would that have resolved the issue?
You know, if they've shown us the policy and indicated that, yes, the appointment, I think we're still going to come to the issue of whether the post was advertised, at what level, what were the requirements. But then if they've shown us the policy and said, this is what was agreed upon and approved, then we would have also well thought about it, because remember, again, we are checking the qualification.
Yes.
Yes.
No,
yes, it would have given us a different conclusion.
yes. All right. Now, let's, Chair, if you allow me, I'm trying, I don't know if I'll succeed. I'm trying to finish this issue before we break. Because as I say, as far as I'm concerned, I think it's done, but we just want to make sure we don't leave any loose ends. Let's go back to the source again, the judgment.
Yes.
Go to paragraph 235, Tsepo, of the judgment. Because we now know that the independent panel's report, Ms. Mazzoni and everyone relied on this judgment to place you where you're sitting now. Two, 235, yes, it's paragraph 81 of the, I'm sorry, typed page 81 of the actual judgment. Yes. So this, let's hear what Justice Bakwa and his two colleagues, Justice Windel and Basson, had to say about this. So, which is the basis for your, for the thing at the end, number 9.
The contention in the answering affidavit and submissions made on behalf of the public protector that the public protector made no finding that Mr. Pillay had no metric and that Mr. Pillay did not provide the information about his qualifications when he was asked to do so is ingenious.
All right. Now, as a matter of fact, we know that you were never provided with a metric certificate. I mean, that's all you said in the report. Okay. And then it says, then the conclusion that Mr. Pillay had no degree and no metric was central to the public protector's finding. That
Yes.
Mr. Pillay was not qualified to be appointed as Deputy Commissioner of SARS. Is that true? Was that?
It's not true because we were looking into the qualification.
Okay.
So it was not only a degree and no metric. That Mr. Pillay had no degree and no metric was central to our, we were looking into the qualification. So yes, indeed, the qualification issue was then something which we received information from SARS, Mr. Makashula, Mr. Kodan, that he had no formal qualification.
All right. Okay, let's just go to 236. And the judge says, accordingly, at the time of the report, the public protector well knew that Mr. Pillay has a matric certificate. Did you, whether at the time of the report or now as you are sitting there, do you know that Mr. Pillay has a matric certificate? Have you ever seen his certificate?
I haven't seen the certificate. And I think that's why in my opening, I qualified the issue that was asked during the meeting when we were investigating the pension matter. And he said, I think we will have to just get that recording. He just confirmed that, yes, he has the metric certificate, he studied way, but I never saw that copy. And it was a different matter, which we were investigating, not this matter.
Yes. In 20, whatever year it was, did he say to you he had a matric certificate, or did he say he did his matric at some high school?
He did his matric at some high school.
And did he give you a certificate?
No.
All right. And then it then says there, well, that's the punchline. Her conclusion in the report that Mr. Pillay does not hold even that basic qualification, notwithstanding the fact that on 25 March 2019, she accepted that this was a matter of public record and was within her knowledge, is astounding. In doing so, she manifested clear bias against Mr. Pillay and material irrationality in arriving at her findings, and so on. And then we submit that this further demonstrates the public protector closed her mind and adopted the process of irrational reasoning. That's really after all those factual issues, this is the basis then for the finding in paragraph 290. Is there justification for that?
There's no justification to that because what I did was that relying on what the investigators or the evidence before us, Chairperson, because evidence before us is very clear. I mean, if you go back to the report, I've shown again that here is the information, which is clear from our report that firstly, when this matter was investigated, SARS response dated 5 February, they did not dispute that Mr. Pillay did not have a matric, a degree. And in this paragraph also, we said he did not possess a matric certificate. Then again, it's Mr. Makhashula who said, Mr. Pillay, the only thing which was done is this goodness of fit. So that's the information which was before me. Thirdly, Mr. Godan in his affidavit says, there is no formal qualification required for the appointment as Deputy Commissioner. Mr. Pillay proved himself amply qualified for the position by his dedicated and service in this process. So there's nowhere where I'm given the qualifications, I'm given the certificates about this matter. Then that's the conclusion which we had to come to as an institution, because the legal framework which was followed, I think Chairperson, I would want us to go there. I don't know whether yes, because the legal application of the relevant legal prescripts, paragraph 97, Chairperson, we say the appointment of commissioner. Okay, before that, SARS saying to us, the file of Mr. Pillay, the appointment was done by cabinet, and then again being told that the file of Mr. Pillay 5.6.12, SARS stated that Mr. Pillay's personnel file had been removed, and in the process, relevant documents had been removed. These included Mr. Pillay's appointment letter, the memorandum directed to Mr. Trevor Manuel by Mr. Godan, which set out the roles of the SARS Deputy Commissioner. And they are saying Cabinet approved the appointment of 3 Deputy Commissioners, namely Mr. Makhashula, Mr. Pillay, and Mr. Gitsveta. So when I approach, or when the investigators in their investigation, we request all these documents. Remember the story of the municipality, because it's basic information. Indeed, we wanted to check when that post was, when he was appointed, what motivation was given, what whether the post was advertised, whether there was proper competition for the position, but it's clear that apparently was appointed by a cabinet. And yes, we wanted to get those documents. Unfortunately, they were telling us that the file has been removed from the well, as HR, they don't have, yes.
Okay, now if you then maybe go to
But any respective, they confirm themselves, including Mr. Godan, that no qualifications are needed.
Yes, if you go to, can you just then just jump to the conclusions, which were at page 98. If you can just read the first 2. Five point 6.26.
All right. SARS and Mr. Godan considered that Mr. Pillay did not possess a degree qualification nor a matric certificate.
Right. Next one.
Mr. Pillay was appointed to the position of Deputy SARS Commissioner on 15 April 2009, along with Mr. Mahashula and Mr. Kisveta.
Right.
Then
Okay.
the
And then-
motivation given by Mr. Godan,
Oh.
which was approved by Mr. Manuel, was that due to the new leadership model being adopted by SARS, it was required that 3 deputy commissioners be appointed for SARS.
Okay, then go to, please jump to 5.631.
It is, however, apparent that SARS did not take the qualifications of Mr. Pillay into consideration in his appointment as Deputy SARS Commissioner. The argument by Mr. Godan that the decision to appoint Mr. Pillay to the position of Deputy Commissioner, Deputy SARS Commissioner, was based solely on Mr. Pillay's previous experience and acquired skill is vague considering the level of the position.
Right. Okay, well, that seems to be then the,
And I think
The
the
gist-
5.6.32 is also very critical because we're dealing with the South African,
SAQA.
yes, qualifications authority, because we are saying another question which I asked the investigators, okay, they've submitted this goodness of fit document. Was this goodness of fit document SAQA accredited? Because, well, knowing working a Home Affairs in the past that we wanted a training, not a training, the training model, but as well the taking into consideration the special skill of the refugee status determination officers. So we had to develop that manual, and that manual we were told the process on how it can also be accredited so that it's a recognized document for, well, policy kind of or document which is properly approved. So this was one of the just internal arrangement, goodness of fit, which was conducted by this consultant, and that's what that was it.
Okay, anyway, I think let's just cut
An
it.
internal succession plan.
Yes, can we just cut it down to this? Whatever, whether Mr. Pillay has a matric or no matric, or whether he has a certificate or no certificate, or degree or no degree. Did your conclusion on the issue of his qualifications, was it because you didn't like him, or because you wanted to target him, or because you were biased against him?
Not at all. I never knew Mr. Pillay. I don't know Mr. Pillay. I don't have anything against him. Not at all, including the very same Mr. Godan. So it was just purely an investigation and supporting constitutional democracy, making sure that the law applies to everyone equally in public administration. The intention was, here's the gap. You can't do this. This is a high position. If you want to do it, have a clear policy, which is properly approved. Also, if you regard this goodness of fit as your document, can it then be approved properly, because SARS is part of public administration. Again, with the intention of guiding future leadership, future administration, do things properly. You have the law which you need to comply with.
Thank you, Chair. Thank you for allowing me that. Unless if there's something that I want to sweep up, I'll move on to something else.
Sure.
After.
Thank you. We're now going to take lunch for 45 minutes. We'll be back at 2:05.
Thank you.
Thank you.
Thank you.
Recording stopped.
we resume and proceed. Advocate Mpofu.
Thank you, Chair. Okay, Chair, I need to raise the issues now.
Now, I will indicate when I want you to interact with the witness.
You said after lunch, Chair.
One o'clock is after lunch, 5 o'clock is after lunch.
All right. Okay, now, thank you, Chair. PP, can we now go to the more generalized section, which it has its own sub issues, but it's just to sweep up on this topic, or rather on this particular report. And before we do that, I just want for you to indicate that two things about the judgment. One is that on the positive side, shall we say, for you, those judges, Bakwa and the others, and as well as the other three judges who dealt with the Pillay matter, found in your favor in relation to at least one aspect, which was the insults held at you by Mr. Kodan and Mr. Pillay, which were found to be, at least in this case, vexatious, scandalous, and irrelevant. You remember that?
Yes, I remember that.
And again, I'm not going to go into much detail on the specific insults because I dealt with those, I think, with Ms. Mkhwebane, but because you are the person who was being insulted, I think we need to just deal briefly with those. You'll remember that the entire attack from Mr. Kodan, Minister Kodan and Mr. Pillay, was that these investigations were conducted by you because you were part of state capture and corruption, and we were colluding with practitioners of state capture, and you're not fit for your office, and those kinds of accusations.
Yes, if you can, think if you're still going to take me through in the judgment or in what they said, because
Yeah,
I need to confirm exactly what
they said.
he
Okay,
wrote.
no, I was trying to avoid that. But as I say, even though we dealt with it with Ms. Mkhwebane, I think we should deal with it with you.
Because they were said to me, yes.
Yes, about you and to you. All right. All right, let's, they are mainly, they're not repeated in detail in this judgment, but they are repeated in the Pillay judgment. Can you go to the Pillay judgment? Did you manage to find it? Okay, good. Okay, go to the Pillay judgment at paragraph Sorry, Chair.
That's okay.
Paragraph 66. Oh, yes, that's the expression I was looking for. Stunning incompetence. That's what Mr. Kodan accused you of. Okay. Now, the background to this is that the allegation was that you were, there's nothing wrong with the so-called rogue unit, nothing wrong with the Pillay retirement. You were just driven by factional motives and that kind of thing.
Yes.
All right. Now, the parts that you wanted are quoted in the judgment. Go further down, Tsepo. Go to paragraph 39 of the quoted part here. Right. This is Mr. Kodan, and we'll remember that Mr. Pillay said he embraced all this.
Yes.
In his
that's
own
correct.
in his own affidavit here. And he said, Mr. Kodan says, I can only conclude that the rush to complete and issue the report within 2 days of the receipt of my submissions and those of other implicated persons was informed by improper and irrelevant consideration or an ulterior motive. By this time, I mean to refer to the presidential inauguration of the third respondent, that is the president, held on Saturday, 25 May 2019, in the political context in which my political opponents have sought to use the complaint lodged with the public protector and now her report to attack my integrity.
I've seen, yes, I remember that.
You remember
and
that, yes.
Yes, the question was,
Yes.
how can he say that? Firstly, that we only took, 48
2
hours
days.
or 2 days to consider their response. And I mean, it means also attacking the integrity or the, the work ethic of those investigators who already had a report which was already been drafted. The only thing which was remaining was to incorporate. And if the matter was going to change the way the report was crafted, definitely that was going to be indicated in the report.
Yes. All right.
And it had nothing with the
To do with the inauguration.
inauguration or when was it. And I think you'll see in the date we issued those reports, the report, there were a number of other reports which are issued.
Yeah, okay. Well, I think I remember bumping into you at the inauguration, so maybe he thought you were rushing so that you can attend it after he was gotten rid of. All right, and then it says there is no other plausible explanation for why the public protector would have effectively ignored my submissions to her on 22 May received in response of the Section 7(9) notice. Well, firstly, did you ignore his submissions in response to the Section 7(9) notice?
No, that's not correct, because in the report, those responses were incorporated.
Right. Anyway, He goes on to say that I believe that the report was issued when it was issued with the findings and remedial action it contains so as to enable a renewal. This is now by you. Listen to this one here. To enable, you wanted to enable a renewal of the ongoing political campaign against me by proponents of state capture and defenders of corruption. So in other words, you sat down in some room with proponents of state captures and defenders of corruption and decided to issue the report on a particular date. Did that happen?
No, that's not correct. That's very wrong of Mr. Gordhan and any other executive, I mean, who is supposed to be subjected to investigation by the public protector to insinuate such issues.
Yes. And he says, it is, I believe that my political opponents, I don't know, okay, and those who are fighting back against the work underway to restore the integrity and stability of state institutions, good governance, and continue eradication of corruption, wish to use the report to attack me and undermine my integrity and good name. Well, I don't think you are, he says you are answerable for that. Then the next one, the immediate reaction to the report from certain opposition politicians and their surrogates was an attempt to claim that I am tainted in some way, unsuitable for reappointment to a position in government to continue my life contribution through political activism for the good of all South Africans. Then it says at 40.4, as set out below, in bringing this review application, I join a long line of litigants who have to run to the courts to ensure that this public protector and Advocate Mkhwebane in particular acts in accordance with the law and the Constitution. This track record of adverse findings against the Office of the Public Protector and Advocate Mkhwebane specifically demonstrates, in my opinion, that she is unfit for the office that she holds and appears unable to lawfully and constitutionally exercise its powers.
So that's the same language which I was mentioning earlier, used by certain members of the executive. They end up finding themselves in the court judgments and end up finding the same wording in the perpetuated in the media. And then in the motions. So that's the choreography I was talking about.
Yes. Then they say at paragraph 68 of the judgment now, it appears in the judgment as if the public protector is contending for these paragraphs to be struck out due to relevancy. I think they probably wanted to say relevance. And then it says, however, in court, her counsel, Mr. Mpofu, took a different stance and in fact emphasized the nature of the amendments contained in paragraphs 38 to 40 and 70 as being scandalous. He argues that the said amendments are so worded as to be abusive and defamatory of the public protector, whose dignity and the applicants are duty bound to protect. That's the section 181 that we read out to the chair.
Section 3, yes.
Yes. The allegations are said to be abusive insofar as they are insulting, and they're also said to be defamatory to the extent that the public protector is being intentionally and without any legal justification accused of criminal conduct without any foundation, thus rendering them scandalous, and so on. And then it's the court then quotes from the EFF Nkandla case, which we have quoted before.
Yes, the issue of, I don't know which paragraph it is, on the raw state power and the most powerful who didn't want to be held to account.
Yes.
Mm.
Oh, no, I'm sorry. Yeah, this is actually not
Not that one.
EFF Nkandla case, yeah. This again, as I was saying, to be fair to the judiciary, where credit is due, this was a quotation from Judge Khampepe,
Mm.
who made the remarks. I think you referred to it some in the morning.
Okay.
Yes, she made the remarks in the EFF versus Godan matter, not the Nkandla case.
Okay.
Okay, and this is what Justice Khampepe had said in that matter, which was one of the offshoots of this matter. You remember, it's the one about the costs, where there was a challenge about the costs.
That's correct. Yeah.
Yes, in the Concord.
In the Concord, yes.
And then this is what Justice Khampepe said in that matter. This matter has garnered much public interest and criticism. It is a matter which has a political bite to it. It is thus understandable why the public would have an interest in it. However, it must at all times be remembered that courts must show fidelity to the text, values, and aspirations of the Constitution. A court should not be moved to ignore the law and the Constitution and merely make a decision that would please the public. I think that's the point you were making
That's brilliant.
earlier.
Yes.
Yes, about not being swayed by the popular and manufactured consent.
Yes.
She then says the rule of law, as entrenched in the Constitution, enjoins the judiciary as well as everyone within the Republic to function and operate within the bounds of the law. This means that a court cannot make a decision that is out of step with the Constitution and the law of the Republic. It must impartially apply the law to the prevailing set of facts without fear, favor, or prejudice. I'm sure you'd agree with that.
That I agree. Yes.
But then the learned justice then said, with that said, courts should not be immune to reasoned criticism.
Mm.
And I think that was the point about Justice Potterell
Earlier.
and
Yes.
so on.
Mm.
In fact, a constitutional democracy like ours, in a constitutional democracy like ours, criticism of the courts and other public figures is strongly encouraged. There should be a robust debate in the public domain on pertinent issues that affect it. However, there is danger in following populist rhetoric and labeling courts as captured and corrupt without sound reasons or evidence. This undermines one of the core tenets of our constitutional democracy. I'm sure you'd agree as well.
That I agree. Yes.
And then lastly, she says, similarly, the public protector is a constitutional servant like the courts, and her office should be afforded respect. It is an office of fundamental constitutional significance, and her powers are not only desirable, but also necessary for the purpose, inter alia, of holding public office bearers accountable. Her role in our constitutional democracy cannot be gainsaid. While she may be criticized, these comments should not be perceived as undermining her office and its constitutional powers. To mount a bad faith attack on her office would surely work to undermine the constitutional project of the Republic. Do you agree?
Yes, I agree with that.
Yes. And then the judges basically then agreed with your argument that Mr. Godan had gone overboard in the insults held at you, correct?
That's correct.
And specifically, it was argued there that, as you said earlier in the morning, some of this even had condescending or even racist undertones, sexist as well, correct?
When we were submitting to court to strike out,
Yes,
definitely, because that's what made me to question those
yes. Yes,
comments, yeah.
yes, and particularly the one that you have already picked out, which was basically saying you would be incapable of dealing with Mr. Kodan's representations in 48 hours or in 2 days.
Yes, because it was like undermining our capability to do our work. I mean, it was just few pages of the response, considering that, I mean, it's 100 and something pages of the report which was prepared. But again, the report, the response was properly incorporated into our report, and it was considered.
Yes, and that is something that you found particularly demeaning and
Demeaning.
condescending, I think.
Correctly, so, because it was as if we don't know what we are doing.
Yeah.
And I mean, the worst part is that his utterances were that, I mean, the public protector, especially the public protector, or Busisiwe Mkhwebane, Advocate Busisiwe Mkhwebane.
Mm.
So it was like,
Yeah.
there's something problematic about me.
Mm.
Yeah.
Okay, and then the court then said that paragraph 77, Justice Bakwa and the others said the premise that the public protector cannot deal with a representation. No, I'm sorry. No, this is not Justice Bakwa. It's remember we were quoting it from the Pillay judgment. Yeah. So this was, sorry, Justice Kubushi. She was presiding, sitting with Justice Twala and Justice Davis.
The Pillay matter.
Yes, in the Pillay matter. It was another full court, yeah.
Mm.
But to be sure, Justice Bakwa and the other 3 judges also upheld this objection, except the only difference is that in the Pillay matter, Minister Kodan and Mr. Pillay were asked to pay punitive costs for this.
That's
and then the other one, the Bakwa matter, they were asked to pay ordinary costs, but that's just a minor difference. Okay, so this is what the judges say. The premise that the public protector cannot deal with a representation received in the space of 48 hours is unfounded and meritless. Firstly, the evidence shows that the report already existed in near complete form at the time of the public, that at the time the public protector received the representations. Secondly, the public protector states categorically in her answering affidavit that when she received Minister Kodan's representation, she analyzed it and found nothing therein to persuade her to change the report. Unless, of course, there can be evidence to indicate that the public protector was lying, that she never actually analyzed the response of the applicants to the Section 79 notice. This remains an unsubstantiated allegation and runs into the Plascon-Evans rule because of the dispute. And this is the part that you were referring to. Then they go on to say, it is also condescending of the applicants to want to argue that the public protector would be unable to deal with their representations within a period of 48 hours. The record shows that indeed the notices were dealt with. They might not have been dealt with to the satisfaction of the applicants. That they might not have been dealt with to the satisfaction of the applicants does not detract from the fact that the representations were dealt with in the report. Thus, the applicant's argument that the public protector did not consider their response to the Section 79 notice is unfounded. The further allegations that she was politically motivated and that ulterior motives informed the report are also unsubstantiated. There is no evidence to establish the allegations, none at all. And then they present what was argued by the other side, Mr. Trenkov and Ms. Leroux, I think. And in the end, the judges found that at paragraph 86, the making of such averments was said to be nothing short of a gratuitous insult by the wrong person in the wrong forum. And this was a specific reference to the alleged unfitness for office.
Can you, it starts with?
It's the making, it's the middle of paragraph
Oh, yes,
86.
yes,
Yeah.
yes.
In fact, maybe let me read it, the previous one, because it's the point that the chairperson made yesterday so well about, which gets forgotten actually, that the Constitution insists that your removal and your accountability should be done by the National Assembly,
Correct.
which is why we're here.
Mm,
Neither the executive nor the judiciary
have
the power to do so.
correct.
And this is what the church has said in that light. More so, rather, on the amendments that the public protector has
The previous paragraph.
86, no, it's the same paragraph, 86.
Oh.
Yeah, just higher at the beginning. Yeah.
Okay.
On the amendment that the public protector is unfit for her office, she contends that these amendments are unwarranted, unsubstantiated, and misplaced. More so as they cannot be lightly appropriately made or pronounced by either a member of the executive, such as Minister Gordhan, or even this court as part of the judiciary, but can only be articulated by the legislature in terms of the doctrine of separation of powers.
That's correct.
Very important. Yeah.
Mm.
The making of such amendments is said to be nothing short of a gratuitous insult by the wrong person in the wrong forum. and then that they should be in any event, making it is gratuitous in the sense that, let us, even if the court agreed that you are unfit to office, there's nothing that it can do about it.
Mm.
Okay. So then it says, we accept that the impugned paragraphs relating to the public protector's fitness to hold office should be struck out on the basis that they are irrelevant as they relate to an issue which, to the knowledge of the applicants, falls outside the jurisdiction of the courts. For, as argued by the public protector, even if the allegations are correct, there's nothing that the court can do because of the separation of powers. The proper approach is to refer such complaints and or allegations to Parliament. Then it says, we're in agreement and we accept Mr. Leroux's argument that paragraph 39, 39, 9, 40, and 70 cannot be read in a way that could be held to be insulting, contemptuous, or defamatory, because they all inform Minister Gordhan's sincere belief. Minister Gordhan sets out in paragraph 38 to 40 his subjective belief about why excuse me, this seems suspicious to him, to ground the ulterior cause of action, and throughout that set of paragraphs, he's very explaining the facts. He's very clearly explaining the facts that he relies on and refers to surrounding circumstances. But then they say, this, however, does not mean that the paragraph should not be struck out. When the amendments made in those paragraphs are considered, whether individually or cumulatively, they cannot be construed as they can be construed as nothing else but gratuitous amendments made based on suspicion. The amendments are therefore vexatious, made and made intending to annoy the public protector. And then they say a similar finding is based on this, on allegations couched in similar terms by Minister Gordhan, has been made in Gordhan, in the Gordhan case, that is in the rogue unit case.
Yeah. Yes.
Yes, at paragraph 267 and 268. They should similarly be struck out in this application for reasons advanced above.
Yes.
And then the rest of it is about the costs. As I said, the costs were the matter was struck out with costs on an attendant client scale in this particular case.
Okay, that's the difference to the other one. Yes.
Yes.
Okay.
And then And I know, Chair, again, I know I've read this before and I've raised it before, even I think on the first day of our appearance here. This court referred to another case which is important for the point that the chairperson was making correctly yesterday. And that is a case of Institute for Accountability in Southern Africa versus Public Protector and others, 2020-5 SA 179 GP.
The one of Advocate
Advocate Hoffman. Yeah.
Hoffman. Yes.
That case, Advocate Hoffman, as he took the matter to court to say the court must declare that you are unfit for office. And the court told him that he was in the wrong shop, as it were.
That's correct.
Yeah. And so this court now, the full court endorsing that decision, said the following. The Court and Institute of Accountability in Southern Africa, when determining whether the Hollington rule applied in relation with the applicability of findings of previous courts to subsequent civil proceedings, held as follows. And I must pause here. For the non-lawyers, the Hollington rule is the one that says that judgments of other courts are opinions of those courts, and so it's an English court. Yeah. And here it says, ultimately, the rationale for the Hollington rule is that the findings of the previous court constitute the opinions of that court, and for that reason are irrelevant and inadmissible in subsequent civil proceedings. If we're at paragraph 95, Tsepo. Sorry.
The same judgment. Chairperson?
PP?
Yes, I'm saying Utsepo is asking the same judgment.
Yes. The very one we were reading. I just jumped a few paragraphs.
To 95 years. Yes.
Yeah. Right. And this is, by the way, this is just the court agreeing with your paragraph 91, where it says, relying on National Director of Public Prosecutions, the public protector in her heads of argument submits that the allegations relating to other court cases ought to be struck out as irrelevant as they constitute the opinions of other courts, the decision of which I suppose I should say the decisions of some of which are still pending. Okay. Anyway, so back to the quotation from the Hoffman case, or the accountability, whatever case. It then says, even though such findings constitute expressions of opinion, they cannot be equated with the opinions of ordinary individuals and cannot be treated as such. Those findings were made by judges and confirmed in certain instances by the justices of higher courts of the land. Judges have duty to form and express opinions concerning issues raised before them. And they arrived at those opinions aided by procedures, including law and evidence, which was designed to ensure that they base those opinions on the correct information. Those opinions are also binding on all persons and those organs of state to which they apply. So the court, as it were, was qualifying the fact that, which is the point I think we made on your behalf on day one, that when one says judgments are opinions, it doesn't mean like it's like somebody walking in the street and expressing an opinion about whether it's hot or cold today. Yeah. But judgments are opinions, nevertheless. And then it says, for all these reasons, the impugned paragraphs must be struck out as irrelevant. Yeah.
Maybe
so,
again, coming back to well, it's just that you are mentioning Judge Advocate Hoffman. The very same complainant in CX, which we will deal with later, and Advocate Madonsela or Miss Madonsela was trying to to correct the affidavit to include that he's an SC. So it's the same complainant, but as well, he's the same one who complained to or took the matter to court to just declare me unfit. He's been just trying through hooks or crook to do that. He even opened the case, Chairperson, the one I went to of alleged perjury.
Yes.
So
Yes, no, it is the same Advocate Hoffman. You'll also remember that in the case of your suspension, the one where it was found that the president acted with retaliation, the first letter ever written to the president to call for your suspension was by Advocate Hoffman in 2020.
correct.
And the president correctly wrote to him to say he cannot do so until this process, until the proceedings have started as identified in 194.3A.
That's correct.
Right. Okay. Anyway, be that as it may, the point really, I think it was for the sake of completion, is to say that both the court, this court and the Rogue Unit Court, made those findings, those important findings, even though obviously, for obvious reasons, they were not reported in the media.
Yes, that's correct. And I think Chairperson and members of the committee, my earlier address about how sometimes the system operates.
Yeah.
It also include some people who will be hell-bent to make sure that you are removed.
Yeah.
And not because you are not working, possibly because
you
are this color which is not supposed to lead this institution.
Yeah.
Unfortunately, then assisted by one of our own or some of our own.
Yes, and that because of that non-reporting, that's why you find ignorant people, or you find some fake outrage, for example, when what is said by the judges here, that judgments are opinions, is expressed. But if it had been properly reported, I think people would not even
will understand.
bat
Yes.
an eyelid.
Yeah, even former public protector, when she was here, she indicated.
Oh,
that
yes.
It was their opinion, yes.
Yes. Ms. Matansela also said that when we put the criticism by Judge Potterill, incidentally,
Correctly.
that it was Judge Potterill's opinion and she didn't agree with it.
That's correct.
All right. All right. Well, so then let's go to then Chairperson okay. The final issue on this is that the judgment, we've now analyzed the judgment and we've shown that all the 9 pillars relied on in that judgment for your alleged bias and relied by Ms. Mazzoni by extension are flawed.
Definitely they are flawed.
Yes. And despite that, the reason why we're here, among others, is that you tried. You did everything in your power to have those flawed conclusions to be changed. Firstly, you went back to those 3 charges for an application for leave to appeal, pointing out some of those flaws, correct?
That's correct.
That application was dismissed.
Correct.
Then you went to the Supreme Court of Appeal to ask for leave to appeal against the judgment.
That is correct.
That application was dismissed by 2 more judges.
That is correct.
So that's now, if you count those other judges twice, 3 judges, 2, 8.
8 judges, yes.
And then you took the matter in terms of section 72(1)(f) to the president of the SCA. That application was dismissed.
Definitely it was dismissed.
That's 9. Okay, 9. And then you took the matter to the Constitutional Court, pointing out those flaws, and that application was dismissed, correct?
Unfortunately, it was dismissed again.
Yes, 20. All right. Now, there's nothing more you can do. I suppose there's no other court to go to. Oh, and you even took no, that was a different matter. The one of chapter J, where this one you didn't take to rescission. So basically, those 9 findings, including this YouTube, I mean, some of them like the YouTube thing, which are so obvious. And the fact that you said you did not see the report, which is nowhere to be seen. And the monster and all those things, Sunday Times, all that survived our entire judicial system.
Definitely, including the qualifications of Mr. Pillay,
Yes.
and the responses. And yeah, all those judges felt, hence my then conclusion, Chairperson, that sometimes what is reported, and we were showing you what Mr. Kodan said. Yes, it was strike out, but unfortunately then there would be those mainstream media, especially News 24 and Daily Maverick, will then pick up and pick those narratives and then report about it. And the more they report about it, that it was strike out, I don't think they even reported about it, but they will still continuously report that the public protector is part of the state capture, connect the dots, she's factional. Hence I said to you earlier, I mean, even your legal brief, instead of informing people properly, lawyers, judges, and advocates, then they sensationalize. That's the problem we have in South Africa. Unfortunately, you won't see that if you are in they are good books and you are not being treated like that. But unfortunately, as I said, as a country, we cannot allow something like that, which still perpetuates the what was used even during apartheid and the Stratcom and the way they character assassinate people.
Yeah.
They might do that to me. I've got the record of that. My family, close friends, they know now how the media operates. But then with this process again, hence I said, those who have ears and eyes, let them see what the system can do to a person and the choreography of the process throughout. So I will plead with judges again. In such instances, give an ear, check all the documents, show that you've applied your mind, you have considered indeed, because a lower court might come to a different conclusion, but when it's appealed, a different set of judges might see something which you didn't see, which I think we've proven here that with the Busasa matter, there was an issue of a minority judgment. Minority judgment, at least it shows that, people have applied their mind. People are not abayi bonke ngati inkomezi yedibhini. I think we understand a Chairperson. Yes, so I think it encourages our democracy to show that at least somebody listened.
Yes.
And not me, because everything I did was doing it for protection of the public. It was not a selfish thing that I want to be popular or to be known. No, it was just purely to say we are doing our work. And that's what I always preach to the staff.
Yeah. Yes, no, I think a translation of that part about inkomezi yedibhini is in English known as herd mentality, H-E-R-D. Unfortunately, I'm not a model C, so I can't say herd. So, advocating powerful. Now, okay, so for me, head mentality and head, this one is the same thing. So, all right. Anyway, the reference then to this issue, I think it's 109.
Of the
Yes. which is really what I was building up to, Chairperson, or linking it to the report under the so-called general section. Fortunately, so that I don't have to fight with the Chairperson, fortunately you dealt with this in your report. And so we can then deal with it, but without now referencing it to the court findings, because we've done it. If you go, Chairperson, to 109, page 109 of the report.
Are you succeeding? Okay.
Where? Oh, sorry. Are you finding it? 109. Yeah. Just go further up a bit to the heading. Yeah.
It's 5.8.
5.8, Chair. The heading there in the report says a response to the allegations made against me, that's a public protection, in the performance of my duties as the public protector. We've covered most of those. As you said, they didn't just start in the court papers, which we've just covered, but some of the remarks preceded this. I think you said earlier in the morning that that's what it was, this kind of thing that made you to have that YouTube press conference.
Yes, this is what transpired, and Chairperson, as I said, I had to also include this in the report just to show how it was difficult for me to do this investigation and also remind whoever is reading this report how I was treated with contempt and what the Constitution, Section 181, Section 182, and Section 6 and 7 of the Public Protector Act was saying. Again, using this opportunity to sensitize whoever, public servants and anyone, to know that, you know, if you are an executive and taking an oath of office, you should be respecting the office, even if you don't respect me, but I think respect the office, which is there if you've taken an oath of office to respect even the Constitution. And there was a number of resistance, as I indicated, the tone which was used, the undermining of the institution, because remember, when I subpoena a person, they appear before me. Hence, even the first meeting when we were doing the PLA, if you listen to that audio, I don't know whether we're going to do the PLA matter, but then you could hear the attitude and the way I was addressed by Minister Kodan, and explaining to him or the mandate of the institution, how we conduct investigations. And, you know, but you'll hear it if we're going to listen to it. You'll judge for yourselves as members of the committee, because you can hear the tone. You can hear when I'm explaining, it's like, you know, you are not saying anything. When my officials were explaining, I remember Mr. Namasisi, Ms. Mkhaladi were there. Yeah, then that's when you could see that he's possibly hearing them. So
who's that?
Mr. Kodan.
Yes. Okay. No, yes. Unfortunately, no, I don't think we'll get to that audio. Even the one where he was kind of abrupt. in dealing, no, we weren't, unfortunately, unless if we have to, Chairperson, okay, I don't think I have to say anything. I don't think we're going to go into the PLA matter in any great detail. I don't need to explain.
Mkhwebane.
Okay, Chair, she
Maybe let
doesn't
me
want to
continue.
confirm. No, we will get into it, but I have had discussions with Advocate. Ms. Mayosi doesn't want
I
to
suppose
confirm.
that important, right?
All right.
Don't engage in whisper. So don't join them.
It was a loud whisper. Ms. Mayosi says, No, it's fine. It's fine. Let it go. It's all right. We can.
Okay.
Yeah,
Okay.
but we won't go into the PLA matter for now until it's confirmed that we don't have to. Yeah, I don't want to breach.
And then paragraph 5.8.1.3.
Mhm,
That's why specifically I draw attention to the conduct of Mr. Godan in the manner which he conducted himself
mhm.
through his legal
Oh,
representatives.
sorry. I'm so sorry, PP. Before you go there, you referred to in your previous paragraph 5.8.1.1, you referred to sections 181, 182 of the Constitution, and then you also referred to sections 6 and 7 of the Constitution. And I just wanted, for the sake of completion, to
Of the Public Protector Act.
of the
Yes.
Public Protector Act, sorry, yes, to the what you left out there obviously was sections 9 and 11
Of the
and
Public
of
Protector
the Public
Act. Yes.
Protector Act. And I think just so that we don't take the members back there, it's again this issue about you being sometimes accused of equating yourself to a judge, but that actually the legislature itself has done that. And section 9 reads, no person shall insult the public protector or the deputy public protector. 9.1. 9.1b, no person shall in connection with an investigation do anything which, if the said investigation had been proceedings in a court of law, would have constituted contempt of court.
That's correct.
And then section 11, which is where the bite is, which criminalizes such conduct, says 11.1, any person who contravenes the provisions of section 3, 7, and 9 of this act, or interferes with the functioning of the office of the public protector as contemplated in section 1814 of the Constitution, shall be guilty of an offense. And any person who 7.11.4, any person who is convicted of an offense in terms of this act shall be liable for a fine not exceeding 40,000 rand or to imprisonment for a period not exceeding 12 months or to both such fine and such imprisonment.
That's correct.
Yes, and the point we make there is that there's no other office, at least that I know of in South Africa, that is protected by contempt proceedings like a judge.
Yes, it's correct.
Not
Hence
even
I
the
said,
chairperson here, you can insult him and not go to jail.
I don't want to comment on that. Yes, because that's what I said. The conduct was tantamount to contempt. And indeed, this also shows the drafters of the Constitution that they wanted to make sure that this institution is protected, because if you are dealing with those who have power, the resources, you should be assisted, you should be protected, and no one must interfere with the functioning and the performance of my functions by anyone. Yes, okay, if you can then, you spoke about tone, and I think that start from 5.8.1.2. Yes, I said there has been a continued tone of resistance and undermining of the functions and integrity of the public protector as a person and as an institution. That's what transpired. 5.8.1.3. Specifically, I draw attention to the conduct of Mr. Godan in the manner in which he conducted himself through his legal representatives who seemed hell-bent not to cooperate with my office, and in doing so also used the media to tarnish and vilify the image of the office and myself as the public protector, because there are various interviews with which Mr. Malachi did with the 702 ENCA, where he was just as well perpetuating all these narratives of me targeting Mr. Kodan and, you know, wanting to deal with him. And I think this was a very, well, if you use media and media is supporting you, then it will be reported in all spheres, because this report also led to a situation where I was even attacked by SACP, for Mr. Mapaila, and there was even a media conference or a celebration. I think it was in collaboration with Gada Asmal Foundation, where they spoke about this as if I'm persecuting people who are working for the unit. And again, not understanding that I was just checking the operations and what laws are violated. I had nothing to do with the people, Mr. Kodan and stuff like that. So that was the challenge which one was facing. But again, because of how the resistance to cooperate with me and the
Yes.
statements made by Mr. Kodan and his attorney.
Okay, 5.8.1.4.
So the above concern that I wish to indicate that the office of the public protector is declared by the Constitution to be one that is independent and impartial, and the Constitution demands that its powers must be exercised without fear, favor, or prejudice. Those words are not mere material or for heroic, as words of that kind are often used. The words mean what they say. Fulfilling their demands will call for courage at times, but it will always call for vigilance and conviction of purpose. So that's what we read, the section 182, which makes it clear that while the functions of the public protector include those that
Okay.
are.
Sorry, Pipi, to cut you. I think that part we have covered. The section 182
Yes.
angle and 181 we covered yesterday. And
the issue of us being proactive as well in
Yes.
our investigation.
yes, and then up to 5.8.1.8, where you deal with mail and guardian. I think we covered that sufficiently
Correct.
before.
But we need
And
to go
maybe to 5.8.1.10 and 11.
I think we also, dealt with the Minister of Home Affairs versus the Public Protector
Yes.
matter, which also helped that it was clarified by the courts, our mandate. And then 10, it is therefore unfortunate that despite the long-standing legal views expressed in the above cases, as well as the empowering legal prescripts, investigations of the matters before my office are still met with resistance and legal challenges by those against whom they are conducted. So, in light of the foregoing, I strongly dispute assertions that I am pushing the agenda of capturing SARS. My only aim is to ensure that the people of South Africa are protected and public funds are not abused in the process of bringing service to our people. So that was the intention of this investigation. So I was addressing what Mr. Kodan said in his responses to our investigation.
Right. Now, in light of these observations, and you've explained why you felt it necessary to actually express them in the report itself, not just in the media conference, which you had done.
Correct.
And just to indicate how strongly you felt about the issue. Having put all this in the report, what then was your reaction when in the court challenge in the affidavit a few weeks later after releasing this report, you find in the very same affidavit even bigger insults than the ones you had faced, such as you being part of a corrupt syndicate, for lack of a better word, or conspiring with peddlers of state capture and corruption.
I think it was very disappointing because then it meant as well the undermining continued. It meant my report was never read. And also reading the report to understand what I was trying to do, understand that there are laws which needs to be respected irrespective of your position, but those laws were never respected. And also we've explained ourselves in the report what we were investigating, what evidence was there. But then he continued to do that before court. And that's what made me realize that no matter what investigation one is doing, it means it's concluded that I've got the attitude or I've targeted Mr. Gordhan, and of which is not the case. So I'm glad that fortunately the judges then could see that this is not correct and this is very wrong. And I indeed applaud and give them credit for doing that, so that each and every person who's litigating, let's focus on the facts before us and the law and forget about attacking each other and, you know, having those opinions which will have a way of degrading the integrity of a person.
Okay. Yes.
No, I
I'm
said I'll
giving
tell
a
the
signal that we might need a 5-minute break.
just to stand up, Chair.
No, I don't know why he's looking at the back, because
No.
the request is to come from there. And unless you want a caucus here, then you indicate that, then you're given a permission for a caucus.
No,
So that
Chairperson.
you don't go through the public protector for your caucus.
No, Chairperson.
We'll take a 5-minute stretch,
Yeah.
it's fine.
The Chairperson
I think they
wants,
saw me straight.
wants to keep this deal.
Might as well just do 5 to 8 minutes tea, that's fine.
You might as well make tea.
Thank you.
And
Recording
then
stopped.
I want to come back and address my issues.
We start our last session of the day. We proceed with Advocate Mpofu. Over to you.
I just want to, thank you, Chair. I wanted to pick out just two issues from the judgment that do not quite fall into those 9 categories, but where I need your comment. The first one is the rogue units judgment. First one will be, I think, at paragraph 104. Pardon? 104. 104.
What page is one page
Page 35.
of the judgment itself? Okay. 104. Okay.
This is where, again, I mean, even if the members of the committee are not lawyers, but at least they are lawmakers. So I think they'll be able to assess just certain aspects. This is about your being wrong in law and all sorts of things. Yeah. Okay, just go to,
Yes, let me.
just go to
Masa, yeah.
101. Okay, I'm just going to use this. I'm not going to, just to see the kind of language or epithets that get used. In 100, it says the public protector has stubborn reliance on an erroneous interpretation of section 3.1. And that's about the whole thing about the Trevor Manuel letter, you remember. And then
Which
100. And then in 101, it says, but in addition to the fact that Skakane report was widely discredited, and then it goes on that we've already discussed that. The one I wanted to take you to is 104.
okay.
Or 103 maybe.
Yeah.
Says, yeah. The public protector, in addition, argues that the report that the establishment of the unit code is improper and in violation of section 209 of the Constitution, and therefore amounts to maladministration as envisaged in section 182(1) of the Constitution and abuse of power as envisaged in section 642 of the Public Protector Act. We went through that. You remember that part in your
report.
In the report, yes.
And I think maybe just to also, okay, we're still coming to 209, but
Yeah.
even the section 3, subsection 1 of the National Strategic Intelligence Act.
Yes, no,
It
that's
was
the
just
one.
purely on testing the evidence and the facts on it.
Yes,
Mm.
I know. But anyway, in 104, then it says this interpretation, that in other words, your interpretation of section 209 of the Constitution is wrong in law and does not constitute a legal basis for her conclusion. On a plain reading of section 209, it is clear that this section does not deal with establishment of covert information gathering units at all. Then it says section 209(1) reads as follows, as we all know. Any intelligence service other than any intelligence division of the Defense Force or police service may be established only by the president as head of the national executive and only in terms of national legislation. Now here's the part. says this section regulates, this is what the judges say, Justice Bakwa and the others. This section regulates the establishment of intelligence services and is confined to the establishment of intelligence services dedicated to the protection of national security. Where does that come from? Is there anything in that section of the Constitution that confines it to intelligence services dedicated to the protection of national security?
I think I don't see it in section 209.
Yeah.
And we've mentioned this section 209 in the report, and it was dealing with intelligence service. But what is also concerning is that they are plain reading in 104 of section 209. It's clear that this section does not deal with the establishment of covert information gathering units. I don't know where did we speak about covert information gathering units, because I think if it was taken into context that we saw the memorandum which was signed by Mr. Kodan to Mr. Manuel, and where they were saying we need intrusive way of gathering intelligence, and they acknowledged by then that this falls squarely within the mandate of state security. So it was under that belief that this information should only be dealt with by state security agency.
Yes.
And it was very clear that the only exception in the Constitution is your intelligence service, and which is established by the president, which is a state security, for instance. And then you've got intelligence in the defense force and intelligence in the police service. So that's how I read this section 209.
Yes. And was the if what Ms. Mkhwebane said that, no, not sorry, not Ms. Mkhwebane. Yes, it is Ms. Mkhwebane, I think. If Ms. Mkhwebane said that the key, some of the key red lights, if you like, of characterizing this as intelligence were interception and surveillance, was there ever any doubt that this unit was doing surveillance and interception by their own admission?
Their own admission, yes. And they also encroaching into the mandate of state security agency. Yes, they were allowed to do the investigations within the law, and especially the demands of the Interception Act, which requires that whatever they do, they need to have the approval of the judge. So the way they conducted themselves, it was surely, and the equipment, which in the long run, it was very clear the kind of equipment which is kept there. I thought we were going to even show the members of the committee the equipments, what kind of equipments were there. And then definitely what they were doing, it was something which was falling within the mandate of state security. And I think this issue that intelligence service is dedicated only to the protection of national security, it's not true. That only to, because everything you do as a state institution, especially state security, you protect your citizens, you protect your infrastructure, you protect everything, and your borders, your sovereignty. So everything which is happening within your borders and encroaching outside of your borders, you'll have to protect. But here we were also dealing with the fact that as SARS, your mandate is investigative. Yes, you can do COVID, you can do this, do it within the law, but then you can't have then systems and equipments like this, which is only state security which can have that kind of capability. And I mean, I think Mr. Pillay even confirmed in the report where he said there is a number of operations they did with state security and the police. So that is what they were supposed to be doing, but not usurp the powers of state security.
All right, thank you. As I say, we'll deal with that, whether that is true or not. The members of this committee, I think, are capable of determining whether Section 209 contains or can be interpreted in that manner. All right, and then let's just, there's something else that I just wanted to deal with quickly is, and this relates, I think, to
Thanks.
Was Advocate Mpofu?
Sorry,
Advocate Bauer?
I don't want to find myself on a parallel universe. Let me just work this out. That was an issue, question of law that was raised on Section 209. Does your argument extend to interpretations of law as well in relation to judgments?
yes. If they're flawed in any way. If yeah, and if they are patently flawed, even to a 1-year-old child, and say something is not there, what is there, or say a YouTube meeting is a release of a Section 7(9) meeting, then you don't need to go to law school for that. All right. So the other thing that I wanted to refer to is 5.4.4, page 101.
Of the judgment,
Yes,
page 101.
101. Yeah. All right. So if, yeah, and this is, I was just saying, sorry, before Advocate Power came in there. This relates to a more general point that will be more pertinent, I think, in CX. About, you'll remember there's that whole discussion about whether when you received a Section 7(9) from Mr. Makashule and you found that it was explaining the issue, then that's it.
Yes, in
remember
the
that
Friede
debate?
matter.
Yes. Oh, I'm sorry. Yes, it's Friday. Sorry. Yes. Okay. Now, I'm just wanting to illustrate that that principle here. You remember yesterday we were talking about the chairperson's favorite topic about implicated parties and affected parties and so on.
Correct.
And then we found that one of the Section 7(9) notices in this matter was issued to Mr. Manuel.
Yes, correct.
Yes. Now, I just wanted to illustrate a situation where if someone gives an explanation to you, you basically let the matter go. Can you go to 5.7.3? Sorry, that's page 100 of the report. Sorry, yes.
The report. Page
100.
100.
It's at the bottom of 100. Yes. Okay, Chair, the heading there is response. You do all the responses from all the 7 9s, but I'm just picking out this one as a to illustrate that point.
correct?
It says response received from Mr. Trevor Manuel to the section 79 notice dated 14th July 2019. So can you read
14 June, yeah.
Yes, 14th June, sorry, 2019, yeah. 5.7.3,
Mr. Manuel stated that the memorandum he signed approved the creation of funds,
the increase.
approved the increase of funds to the NIA's budget to create a special capability within the NIA to support SARS in its efforts to tackle the illicit economy.
0.4,
Mr. Manuel argued that the memorandum he signed approved the transfer of funds to involve the NIA in supplying SARS with the necessary intelligence. Therefore, there was no wrongdoing on his part.
yes. Now, so that was the explanation by Mr. Manuel. Did you then accept that explanation?
Definitely, the explanation was accepted, and hence there was no finding against Mr. Manuel. In fact, yes, maybe remedy or finding against Mr. Manuel.
Finding or remedial action?
Definitely, and I think this one also is very clear that Mr. Manuel understood the request as I understood it, because he said this was to fund NIA so that they can provide the necessary intelligence to SARS, not
Yes.
SARS usurping what NIA should be doing.
Yes. In other words, and I think Mr. Godan make that point somewhere in either in these papers or somewhere else. So just so that everyone is clear about this, there were two, effectively, in that famous letter, the two types of approvals were envisaged. One had to do with money, and that was
Correct.
treasury, obviously, that Mr. Manuel's baby. And the other one had to do with the memorandum with NIA, and that would have to be approved by the Minister of Intelligence, whom I think at the time was Minister Kasrans.
That's correct.
Correct? And the one by Mr. Manuel was approved, as he indicates here, but the other one by Minister Kasrans was not approved. The NIA thing.
Yes, it was not approved.
Yes.
Correct. Yes,
And they also said NIA lost the appetite, whatever that means.
that's what they said.
Yes, okay. All right, so therefore, then Mr. Manuel had nothing to do with the operations, whether it's covert or not covert, or whether it's interception. He had approved the part about the money.
The money and the part about willingness to cooperate or sign the MOU so that they can support SARS with intelligence.
Yes, okay, good. So once Mr. Manuel then gave you an acceptable explanation in E79, or was there anything else you could find against him or ask him to remedy?
There was nothing which I mentioned, which was supposed to be done by Mr. Manuel, but besides the minister.
Yes. All right. Now, if we go to, I'm moving to something else now. If we go to page, paragraph 252 of the rogue unit judgment. Now, Judge Bakwa and the others now refer to you in a particular manner here, and let's just 252. Starts with but.
252.
The sentence
But
that starts with
the-
but.
But the demand made on the Minister of State Security to implement in totality the OIGI report dated 31 October 2014 is the most astounding of all the remedial action contemplated by the public protector. Firstly, the possession or use of a classified report would clearly constitute criminal conduct on the part of Advocate Mkhwebane, who as a former state security agency operative remains bound by national security and intelligence legislation.
Yeah. Okay. Well, the judges call you a former state security agency operative. Are you such a thing?
No, not at all. Hey, I never saw this one. Phew, Chairperson.
So you've never been.
No.
And you even missed this part in reading this.
I never saw this part that I was, no, I was never, I remember you asked SC yesterday, but I said to you, can you show me in the judgment why am I referred to as that? Because now this also then perpetuates, and I remain bound by the national security and intelligence legislation. That's so wrong. It's not true. I was never a state security agency operative. A state security agency operative to anyone who cared to listen. I think possibly they were listening to what DA has been perpetuating, that I'm a spy. And I mentioned over and over, Chairperson, that I was appointed by state security in July 2016. I was working for the Department of Home Affairs all these years, and until I was transferred to China to work for Home Affairs under DERCO as a public servant. And I mean, it means then judges, then they take whatever is being mentioned by DA, which firstly, they never supported my appointment, and they accused me of being a spy, which till today, they've never proven that, because I took them to court, which again is being questioned why I had, as a public protector, take them to court, because they were accusing me because of this process that I'm a spy. So this is very derogatory and to them, and hence I said even to the DA, you cannot say when I was in China, I was a spy. What are you doing to the relationship between South Africa and China that then they can deploy somebody at the embassy and under the guise that the person is working for Home Affairs? And I said, there are relations, there are officials from SSA who are operating overtly, like they are known, they are based, they are from SSA, they are based at the embassy, they are working with the intelligence of that other side. And now when I'm labeled an operative is somebody who operates underground, who's not supposed to be known. I was never that kind of a person, because I was supporting the director of domestic branch with whatever information I know of, the application of the constitution, the law, and what I'm supposed to be doing. So this is so wrong. And again, it's being perpetuated from the media, what the DA is saying. And it's very concerning that judges will then include something like this in their judgment, because now I don't understand why this is, it's shocking actually. And I think I indicated, Chairperson, in my responses to you and members when I was asked about this classified document. And I indicated that being the public protector, having the top security clearance, and hence the issue of wanting to have staff members within the office and anyone who's working in that office should be having that top security clearance, so that we don't have situations like this. And now it's perpetuated by even Honorable Gondwe in this questioning and creating all the doubt in people's mind that possibly state security was running the office. State security is a constitutional institution. I said it repeatedly. State security should be at the core of each and every department's operation, of each arm of government's operation. Hence, I think my predecessor even mentioned that why judges and members of the executive and members of parliament are not. Actually, I think I even said in other countries, well, I was based in China for 4.5 years. You can't have people who are working in state affairs whom you don't know who's controlling them, because if you're doing security clearance, it's not just sitting here being interviewed and then you check my things. State security clearance goes deeper, which I think this country must reconsider, because then you need to know Mr. Janchi or the chairperson of Honorable Janchi, your relations, your bank statement, who's paying you, who's controlling you. Because some people you'll find that they are paid by foreign intelligence, foreign countries. You know, hence as well, you find some NGOs who are funded by those foreign intelligence. And I even said it in the past that some people are operating in the country as journalists, whereas they are paid by foreign intelligence to cause instability in the country. That is never spoken about. And I think state security should be the one which is educating South Africans why it's critical to have state security. And Honorable Gondwe, they are sitting in parliament for a country, because we are doing it for the country. Now, when you have members of parliament exposing us and exposing our generations to come, we are just saying in your house, the neighbor can come in and kill and do anything to your children, because this is meant for doing that. So I think judges as well should be respecting that. And I don't think it's fair to be labeled that, but it's not in a wrong way as well to be a state agency, security agency operative. It's good because those people are risking their lives to protect us as South Africans.
Okay. Well, I allowed you to, well, I didn't want to stop you, but maybe next time when you make examples about MPs, use me as a chair, so you're not accused of picking members of the committee. Thank you.
Thank you. Yes. So I'm, as you know, I'll welcome that opportunity. So the chair accused you.
It's referred to the public.
It's only confined to. Oh, I was going to say, I remember the chair accused you of being a spy. Yeah. For example. All right. No, but more seriously, what is to be done about this? If you, as you say, the narrative, which we know started on day one of you being a so-called spy, then it got into the media, of course, and it's perpetuated there. Then it's repeated by Mr. Godan in his affidavit, because I think that's where it came from. The church has just regurgitated it from Mr. Godan. And then Mr. Godan, the church is repeated here. And then it gets to Mr. Mazoni's motion. Then it gets into this committee. But all along from day one, when it was started in 2016, it was a lie. And something that you have vehemently denied. And you say you have even gone to court to litigate about it.
That's correct.
So what must happen with this, if the judiciary does, or it becomes a conduit then for such statements?
This proves what I said earlier, that judges should not be entangling themselves into, because they know that when something is reported in the papers, when the accusations are made out there, give yourself time to, don't just take that as gospel truth. well, with us, it's good that we're doing investigations, just don't do investigations. But then I cannot be accused, I mean, have a judgment like this, and that it's a criminal conduct. They use the possession, which is also wrong because that legislation is very clear. Possession of a classified document, which I answered, is not a criminal offense. Or they use, but there was the various other steps which they are indicating how it needs to be done. And I mean, if they could see, I went into pain to declassify this report. I had to meet ministers. I had to. So now I'm accused with something like this. Again, this is clear evidence that judges don't just take the narration, the issue of the choreographed process. Executive says this, media reports about this, manufacturer concern, judges in their judgment is there. Now, the same thing is now, I'm here having to account to the this motion with something I was never a, well, yeah, it's.
No, thanks. Now, the point really is, well, 2 points. First one is, I remember the chairperson was jokingly referring to your interview on television where you said, I think it was 2 days before we started here, you said, why don't they start today? And that's another narrative, by the way, which when you said you were so eager for this process because you wanted a platform to deal with these matters, although you've been accused by all sorts of people to say, no, you're running away from testifying. But the point is of the matter is that I know from personal experience, if you could have been called by as the first witness, you would have wanted to be like that, because there's nowhere else where you could have dealt with these judgments. You had, in this matter, so you're called a former security state agency, agency operative by the lower courts, and the SCA confirms the judgment, and the Constitutional Court confirms the judgment. So after that, how can you ever deny? If someone says you are a security state agency operative, then you have to accept it because the highest court in the land has confirmed it. Now, the issue really is, when I say what must happen, about those kinds of situations where a matter might have gone to the highest court, yes, we accept, then there's nothing more you can do. Not everyone has a chance to have a process like this where they can ventilate the issues, thanks to Ms. Mazzoni. But what should happen?
You know, we can say that again.
Mr. Skakane had some
can say that again,
suggestions.
that maybe thanks to her, you know, as a Christian, they say everything happens for a reason. God allows one to go through this humiliation for the past 6 months, vilification, and people, you know, I trust that speaking very painful and, you know, derogatory information, and still perpetuation of me not knowing the law of all those things. And thanks, Chairperson. I think I'll give as well credit to you. Yesterday, you mentioned that this process, yes, we are not reviewing because anyway, they've concluded, but again, it's a lesson to everyone. And I said it that, fine, I've been put into, I've been sacrificed, I've been humiliated and everything, but it's for the good cause of our generations to come. And thanks God that this will remain the record of this hearing 20 years, 40 years, or 100 years to come, that yes, there was this judgment, but this is what actually transpired. And this is what I've said myself, that I was never this. You can check my records, you can, you know, because I was not at all hiding anything. And even if I was a state security agency operative out there, you must know yourself that you are doing what is best for the country. You are protecting us. With me, I was never that. I'm here now as the public protector, and I'm trying to correct and make sure that we say we have this constitution. Unfortunately, in South Africa, then we call ourselves a constitutional democracy, which it's another debate for another day, but let's as well stick to that and correctly deal with matters. I think SCA and Concord and the judge presidents, when you are requested to reconsider, take your time, go through the records, you know, and just be objective, because you are there to do that. You need to make sure that justice is seen to be done. Lady Justice should be blind, irrespective of Mkhwebane. You've heard, you've read, but from now on, don't just take whatever is reported in the media as gospel truth and just conclude as well yourself. And that is the case. And you must also know that any country has an interest in your country, unless then you know that when this country comes crumbling down, you can go to another country. But if you are a South African, truly South African, you care about South Africa, these are some of the things which you should very much be careful about, because you can't just use the country like that.
Yes. Right, thanks. Okay, so fine. We'll move on. Well, I think the point you're making is that it's factually incorrect, not that there's anything wrong with being a former state secretary.
Definitely.
It's like if someone said you are a member of parliament, if it's factually incorrect, it's factually incorrect. It doesn't mean there's something wrong with being an MP.
Correct.
Okay. All right. Now, thank you. The last point then on what I wanted to sweep up there is, I just wanted to assure you, because you were referring to the KPMG matter, that at paragraph 346 of your statement, it's dealt with and maybe 348. Can we go there quickly? And while we're there, we'll also deal with the other point we made yesterday, which is that based on the same information, the NPA also found enough reason to charge, or enough prima facie evidence of the rogue unit activities to charge the persons involved. So can you please read 348 and 349, which incidentally are the last paragraphs of your rogue unit part of your statement?
Okay. So 348, coincidentally, the KPMG and Skakane report made a finding that the establishment of the intelligence unit was unlawful and in contravention of Section 209. I pause to explain that although the Skakane and KPMG report came to our attention during the investigation, we were never influenced by their outcomes and conclusions. PPSA investigations were independently conducted, which resulted in their own conclusions based on the evidence and information before the PPSA investigation.
Yes. Yeah, let's just pause there and just again, as I say, just to juxtapose the fact that although you refer to those reports, they did not replace your work, as it were. They do exist, but was the point to simply imbibe or regurgitate their findings?
You know, the two reports which were commissioned by SARS, again, state resources were utilized to commission these two reports. I indicated that the Skakane one, it was clear that Mr. Pillay commissioned the investigation, and the KPMG report, I'm not sure it was Mr. Moyane or who commissioned, but KPMG, the fact of the matter, Mr. Moyane, the fact of the matter is that even though we received those two, then we went further to ourselves engage SARS, get the information, also get the recordings relating to the operations, get the policy of SARS relating to the establishment, the appointments, and relating to the procurement of the equipment. So we've referred to these reports, but at the end of the day, we've conducted our own investigation because of the Rule 53 record, which we've availed. It was showing that this is all the information which we relied on, and the interpretation and coming to the conclusion that Section 209 requires a state security agency, police intelligence and subs intelligence, but then for SARS to conduct such, it's not provided for in their law, and they should have possibly acquired permission from the president to do that. Alternatively, they shouldn't have even continued to do this work without collaboration with state security agents. And remember, again, going back to what Mr. Pillay said, that they've done a number of those. So in hindsight, they should have continued to do that, conduct operations with state security, because it's a state institution, it's a constitutional institution, and they've got the expertise. Instead of employing new people, let them work with them and collaborate with them to do these investigations.
Right. And
So 349.
no,
Okay.
We'll get to 349 just now. Just want to finish the issue of the reports so that we don't come back to it.
Just bring the mic closer to you.
Oh, I'm sorry, Chair. I didn't realize that. Now I'm saying we'll come to 249 just now, PP. All right, can we, I don't know, maybe Ms. Advocate Power will assist me. I'm looking for, okay, I think it's bundle D, item 2, folder 2. Bundle D, I'm looking for the IGI report. And incidental, while we're waiting for it, Public Protector, are you aware that the,
Maybe before you proceed, so that
sorry,
she wants to clarify something.
Advocate Mkhwebane, we haven't uploaded the
haven't?
declassified IGI report.
Okay, well, it's not, it's yeah, that's what I was covering now. The declassified report is on page, you have, go to bundle D, item 2, folder 2. This might have been submitted by Mr. Van Lochenberg, I don't know, because it's his.
It's a declassified copy.
It's a declassified copy. Yeah, no, okay, Advocate Bauer forgot, and it's that time of the day. Item 2, yes, folder 2. Bundle D, item 2, folder 2. And I'm looking for page, the declassified IGI report starts at page 120. No, sorry, 220. Oh gosh. Sorry, I've just removed my flags. Sorry.
While still looking for it, so we finally got the declassified report. in the remedial action, which was what we requested.
Well, Mr. Van Lochenberg was more successful than you. He put it as an annexure. I don't know where he got it.
Yes, because it's declassified. If it was also declassified when I wanted it, I would have used it and it would have been part of Rule 53.
Yes.
Mm.
In fact, now that you've mentioned that, this can save us a lot of information and questions that we ask them. Can you look at that document, the
Yes.
declassified report? Just run it. The Office of the Inspector General of the report of an investigation into media allegations against the Special Operations Unit and or other branches of state security agencies. And go to the next page. It's signed by,
Declassified, yes.
yes. It's, yeah, well, it's the stamp that says declassified, so the chairperson won't be arrested for releasing. Okay, but now I was looking for more of this, the signature. At the bottom of that, yeah. It says signed in Pretoria on 31st day of October 2014 by Ambassador Advocate F.D. Hadebe, Inspector of General Intelligence.
That's
See
the
that?
one. That's the one. Yeah.
And then just look at the introduction, next page. Terms of reference. Anyway, I think I've showed you enough. All I want, I think I'll ask you, is this the document that was dropped at your office by an anonymous person, which you discussed with Dr. Dintwe and various other people?
Yes. Can you scroll it down, Tsepo, before I finally say it's okay?
For the
The
terms of reference.
Yes.
Then maybe I can just, okay, let me do this. I'll ask you the question at the end. I'll take you to some of the places I wanted to take you anyway. And in the process,
Okay.
just try to see if it's
Yeah.
the same document here.
Mm.
So that we kill two birds with one stone. Go to 2.5 Tsepo, that's 247. Because remember, Mr. Van Lochenberg said they didn't give him his right to be heard.
Yes.
Yes, just read the first paragraph.
Mr. Van Lochenberg was interviewed on 2 occasions. Must be noted that he was legally represented by an attorney and 2 counsels on both occasions. In the first interview, he attempted to direct the interview by proposing that he has 38 themes on which he would like to advise the OIGI team. Coupled with this, he provided the names of 64 people he felt the team should interview to understand the issues at hand. He was advised that he should desist from directing the investigation and the team will decide what questions to put to him. Mr. Van Lochenberg indicated that the interaction between SARS and SSA started when, so then that was blocked out, and requested a meeting. The meeting occurred on the 15th of November, 2010 at the behest of, so protecting some of the people which they needed to protect, yes.
Okay, fine. Then just go to 251. Middle of the page that says during 2006 and 7.
During 2006 and 7, Mr. Manuel, the former Minister of Finance, raised a number of concerns about the illicit economy and SARS capability to address this. SARS made a proposal signed by the commissioner, by the then commissioner, Mr. Pravin Gordhan, Mr. P. Gordhan, on the 8th of February 2007 to the minister to fund a special capability within the NIA to supply SARS with the necessary intelligence to address the illicit economy. It was made clear in the proposal that SARS does not have the legislative mandate for clandestine activities.
Okay,
So it's the
Right.
same
memorandum, yes.
memorandum.
And then
And-
right at the bottom, interestingly,
Must I start?
interestingly,
Yeah, okay. Okay, interestingly, the memo indicated that fundamental to combating the illicit economy is the capability to penetrate and intercept the activities of crime syndicates. Scroll up. In addition, the memo was for the approval of 26 personnel with specialized capabilities, which was attached then. So the same memo is the one which we've seen here and we've presented.
okay, next page. Early this year. No, sorry, it was the same page. At the bottom. Early this year.
After where Mr.
After
Pierre.
HR, oh yeah.
Yes. After the media exposed, most of the members of NRG
No,
were
it says
redeployed.
early this year. That's after the sign with.
Early this year.
Yeah.
One member left. On the 28th March 2008, Mr. Van Rensbeck, Janse Van Rensbeck, who is called Scully, indicated he was unwilling to be redeployed according to an internal memorandum dated 28 March 2008 and signed by Mr. Ivan Pillay. He was given a settlement package of 3,150,000. Mr. Ravella stated that he believes that Mr. Janse van Rensbeck Scully was going to expose the unit and blackmail both Mr. Pillay and Mr. Gordon. He stated that Mr. Janse van Rensbeck Scully initially demanded 10 million, which was reduced.
Okay, then there was the issue of Mr. Van Lochenberg, who admitted that this whole thing started when his girlfriend started to spill the beans. So let's go to 253. On 28 May.
On 28 May, Ms. Walter lodged a complaint with SARS alleging that Mr. Van Lochenberg runs a covert intelligence unit that has surveillance and interception capability. She indicated that the NRG still exists under the name High Risk Investigation Unit. This unit in its current form comprises of 6 members who report to Mr. Van Lochenberg. This unit does not operate from SARS premises, but operate from home, well, they wanted to say from home premises, as they should be, shielded from the rest of the organization, considering the high risk nature of their work.
Yes, and then, okay, let's go to 256.
In the interview, Mr. Ravel.
No, 256
okay.
At the bottom, number 6. So the people's names are obviously blanked out.
Yes, that's what we were worried
You-
about. Yeah.
You and
Didn't we?
didn't know the
Or
names.
even the
Yeah,
DG of
okay.
state security, yes.
This was also.
This was also corroborated through an intercept. If the intention of Ms. Walter was to discredit Mr. Van Lochenberg as payback for the breakdown of their relationship, allegations of disclosing taxpayer information would suffice as it is a serious enough, it is serious enough to warrant dismissal. She could only have known about the interception capability of SARS through what she was told and shown. There is no other way. Even more convincing as to the veracity of her information is that it has in all material aspects been corroborated by persons within that covert unit.
Next one.
There is further corroborated evidence to the effect that SARS, knowing fully well that it does not have a mandate to conduct covert intelligence collection in support of its activities, approached NIA with a view for NIA to establish a dedicated covert capacity under the aegis of NIA, subject to the signing of the MOU between the two institutions. However, the MOU was never signed and the proposed dedicated covert intelligence capacity never took off. It is against the aforementioned background that SARS then took it upon themselves to establish a covert intelligence capacity, considering that the proposed initiative with NIA was not successful.
Right.
So that's the one way they proposed and Minister Castrels never signed.
Okay, next paragraph, 258.
It is
Page 258.
So these are the findings. Evidence shows that SARS created a covert unit utilizing covert and intrusive methods in direct contravention of the SARS mandate as provided for in the Tax Administration Act. We find that only the President, in terms of Section 209 of the Constitution of the Republic, 1996, may establish any intelligence service by way of national legislation. No evidence exists that the President established an intelligence capability within SARS.
Okay, so let's stop there. So the people who should know better were the Inspector General of Intelligence. Did not think that Section 209 is limited to, I don't know what the judges said, some whatever, security.
National security.
Yeah. No, sorry. The Judge Bakwa and the others said, this section regulates the establishment of intelligence services and is confined to this establishment of intelligence services dedicated to the protection of national security.
That's what they said.
All right. Now, then, all right, can you, then maybe the last one, if you could. Let's go to 2.9, next page, 259. That's really the one that you then quoted in your report.
Yes, correct.
Number one.
Number one, it is recommended that criminal charges be investigated against Mr. Pillay, Mr. Godan, Mr. Van Locherenberg, and Mr. Richer for the establishment and involvement in the covert intelligence unit in SARS. It is recommended that statements from Mr. Piercha, Mr. Fitoi, Mr. Scolish, Jansen van Rensbeck, and Khatebe are obtained in support of criminal charges. Ms. Walter has provided a statement in this regard to the DPCI, the Hawks. It is recommended that SARS produce a credible inventory of all operational equipment which were used over a period by SARS NRG in the course of its covert activities, which must be confiscated and handed over to the mandated structure.
Okay, now what Mr. Kiswetter has written to the chairperson of this committee to say that I suggested that the equipment belonged to the rogue unit and it was wrong. Is this equipment they're talking about here the same equipment to your knowledge?
That's the same equipment, because remember there's somewhere in the report where we are saying it was clear that the unit was already operational even when they were approaching the minister to approve. And then the documents which we had, which were SARS documents where there was issues of the spending of 40 million or requesting for deviation, the procurement of the equipment, and the charge sheet as well, where they mentioned and the photos of those equipments. So it was very clear that it's equipment which is of a specialized nature, and it's equipment which is only supposed to be utilized by SSA and a very much guarded and responsible way within the limits. And as I said, Chairperson, yesterday, Pella, you know, if this equipment in the hands of wrong people, the activity is rogue in its nature, because then it means they do as they please. It's so intrusive, the way they could utilize the information. So it was just making sure that we don't have a situation where people are not protected. As much as we were discussing with Dr. Dintwe and Advocate Gavenda, because if you listen to that audio as well, the things they are saying there, not about this unit, which for me I was concerned about, but what the others were also doing, you know, plundering state resources, buying equipment, stealing things, you know, just to create havoc. And what does that do? It's for us who only have our home country as South Africa, because unfortunately, serious, Chairperson, this is serious because, well, if you take a world view and understand how, because no country will love you, unfortunately. As a country, you need to protect your country by all means, because yeah, if they can just attack you, they can do anything. I mean, state security is one of the key, because they need to protect, and we can't have equipment like those being in the hands of wrong people or people who can use that for their own nefarious means. So it's just that, yeah.
Yeah, can you read the rest, number 4?
The fourth one, the other one is that it is further recommended that the law enforcement agencies currently investigating allegations against SARS and Mr. Van Locherenbeek in particular continue with the investigation with the aim of preferring criminal charges. And then it is recommended that the investigation by SSA on the covert unit within SARS continue in line with its defensive mandate. So those were the things which they wanted to be done. A further recommendation is that the investigation within SARS headed by Mr. Ravel be concluded as soon as possible. It is recommended that the payment of legal fees of Mr. Van Locherenbeek by SARS be immediately stopped. Finally, it is recommended that the report of the initial SARS panel be approached with caution, and that the second panel established to investigate the allegations conclude their investigations as a matter of urgency to enable finalization. So I consider this report, and indeed this is the report which I saw, which was dropped at the reception of the Public Protector Office. And that's why I said yesterday, Chairperson, the only focus was on what legislative framework has been violated, and it has been mentioned in the Public Protector report independently as well, checking that, because Mr. Mataboga, I think, said he never read the report. Me reading the report, also possibly guiding that you look at the following legislation, but Section 209 was definitely also mentioned in the complaint.
Yes. Okay, thank you. Now, 2 things that must be said about this. One is that at the time that you read the report, obviously we know that the quote unquote good authorities that you spoke about effectively confirmed that it was the same report as you are confirming now, correct?
Correct.
The second issue, which is important, is that all this that we are reading now, including the declassified report, was part of an application by Mr. van Lochenberg, issued in December 2019. I don't know when it was granted, probably in 2020, whose aim was to set aside that report for 2 years later after your report, correct?
That's correct.
And you were not cited in this application.
Yes, I was not cited.
But this application was Johannes Hendrikus van Lochenberg and the IGI, whoever it was at that stage, and Minister of State Security. And in the notice
By
of
then it
motion,
was Minister Tlotlo, yes.
it was Minister Tlotlo, yes. And we now know that in 2020, I think, that application was granted, correct?
That is correct. I think what we should have mentioned as well with this report, when I'm reminded by it's a criminal offense to use or to be in possession. We should have mentioned the Judge Sunderland matter, because they used and they said it can be shared. It was even before then the Pretoria High Court set aside this report. And when it was used, or I was going through, by then it was still the official document of the State Security Agency.
Yes, no, evidence was led here that Judge Sutherland, I think it was in relation to Mr. Matabuche, that Judge Sutherland indeed said, because for the same reasons as Dr. Tinto, that because it was already in the public domain, there was no point in dealing with it as a classified document.
No, I'm just focusing on this, Chairperson, because I'm concerned about that paragraph. Actually, I'm still shocked. That paragraph of being a state security operative and that it's a criminal offense. When because it refers to me. Yes, you might have raised it, Mr. Matabuche. But for me, I want us, the Chairperson and the committee members, to consider that judgment, Sunderland, and what he said about that particular report.
Yes. No,
Yes.
okay. So you want us to present it again? I've got the judgment. It was referred to, sorry, Chairperson. Actually, had it here. I was just going to
because it links up to what I didn't completely finalize, because I thought we will call Advocate Govender, but again, media reports as if it's a criminal offense to have this, and not having any qualifications to that effect. So it should be clear out there that even judges use that particular document.
Yeah, okay. Now we're coming to that. Can we just finish this part, because we have to be fair to the judiciary, as it were, or to everyone. Although we have agreed that we won't deal much with things that happen subsequent to the reports, but I think here we must make an exception and make it clear that the IGI report was subsequently reviewed and set aside.
That's
we can't
correct.
just quote it and then say nothing about that. Yeah.
That's correct.
Now, the point I'm making is do you know the circumstances under which that report was reviewed and set aside? Was it an opposed application? What actually happened?
It was not even an opposed application, because when I heard about it, again, it's hearing in the news that I think Minister Lomo at first, I don't know whether he or she opposed or later then withdrew, and they just filed a notice of abiding. And that was all what happened. And as well, not being quoted as the public protector, because it had also a direct impact on our work, but it was fine because our report was out there, and the report was declassified, the remedial action was implemented.
Yes, and then, thank you. No, I'm saying that because Mr. van Lochenberg, I think somewhere in one of his goes on about how that report in any event eventually was set aside, but obviously not being a Sangoma, you did not know that in 2019.
Correct. It was after the fact, yes.
Yeah, all right. Now, if you go to the Sutherland judgment in page 465, I think, under judgments, I hope it's the same. It's bundle H item 31, item 31.5.1. Okay, while they're looking, Chairperson, you'll remember this is in relation to not the declassified report now. The classified report, before it was disclassified, had been put into court papers by Mr. Julius Malema in a matter called Pravin Jamnadas Godan and Julius Malema Freedom of Expression Institute. And Mr. Godan in that case took the point that it should be discarded because it's classified. That which it was at that stage. This was 31 October 2019, the date of this judgment, and Mr. van Lochenberg's application to review it was filed in this 2 months later. Right. So paragraph 25, just show the heading. Yeah, those are the parties. Yeah, then go to paragraph 25. Start at 24.
This stance provoked an application to strike out these inclusions on principally the grounds that they were irrelevant. The three inclusions were a report of the Inspector General of Intelligence of 31 October 2014, the IGI report, the report of the Commission on the Cabal of 14 March 1990 in its form as found on the O'Malley Archives website, the Cabal report, and the so-called Skakane report of 5 November 2014. Of these reports, the IGI report stood in a distinctive category in that it was a document admittedly classified secret that had been allegedly improperly leaked into the public domain. To deal with this document as a special case, the application to strike it out was heard in a preliminary hearing. The application was dismissed and the costs reserved for the main hearing for determination.
Okay, then can you go to paragraph 29?
A reading of the report and of the minister's rationale of excluding it from the public domain reveal that the rationale is wholly unfounded. The burden of the minister's perspective is that agents of the security agencies may be compromised. No agents' identities are disclosed. The persons described are not secret operatives in the list. Moreover, at the time the document was attached to Shivambo's affidavit, the document was already in the public domain and had been the subject of media reports. Any confidentiality claimed for the document is futile.
Okay, thank you. All right. Now, again, I think we've already established all that happened even before it was declassified. Well, I don't know when it was declassified, but at least before Mr. Van Lochenberg's application, correct?
That's correct.
Okay. Thank you, Chairperson. That would then conclude the section on the
Before you conclude that, there was the charge, and that's the last one, I think,
charge.
that NPA charged them. The last paragraph on my affidavit on this matter.
Oh, 209.
Yes,
I mean,
the-
354.
Yes.
Sorry.
349.
Yes.
Notably, it
The
is
one about
common-
the Pretorius. Yeah.
yes.
Okay, hold on one second.
That's the last one on this matter.
Yes, but it's page 151, Sepo. 151
there.
of the yes, no, yes, before rather the Pretorius thing now, 349, yeah.
Notably, it is also common cause that based on similar information as that at my disposal, the NPA, per advocate Pretorius SC, found sufficient prima facie evidence of criminality on the part of inter alia Mr. Pillay and Mr. Van Lochenberg, to the extent that they were criminally charged and made a few court appearances before the charges were withdrawn. I'm in the process of securing the evidence around the mysterious withdrawal of the charges. What cannot be disputed is that they were indeed charged.
Yes. Okay, yeah, just to make it clear for that this is not the advocate Pretorius of the Zondo Commission fame. This is an advocate Pretorius who was a member of the NPA who signed that criminal, what do you call it? The charge sheet, yes. And Chairperson, you'll remember in one of your meetings, you discussed this, we had made an indication, not an application, that we would call someone from the NPA to deal with this. But I think your indication was that you would have to see a statement and so on. But so that was the person. The advocate Pretorius inquiry led us to that somebody else, but I'm just mentioning that in passing.
Yes, that's the last issue.
Yeah.
That there was
Thank you.
something like that. And as well, during the proceedings, there was a stage where I said to Mr. Mataboge, maybe if you wanted to check the availability or where we can find Mr. Van Lochenberg. But then later that was stopped because we said, anyway, we'll find him with this part B of the investigation.
Yes.
So part A for now, let's keep it.
Yes.
And I think one thing I also want to just clearly state, SC, Chairperson,
Yes.
is this section 7. If we can just go to section 7, not section 7.4. There is section 7.1, I think Roman figure 1.
Of the Public Protector Act.
Yes, which I was using in most instances. I remember we came to Masphumelele and we conducted that investigation, and I served the then Mayor Delil and the then Premier Zille to subpoenas. And they were also concerned, why are you subpoenaing us? Because we are cooperating. But it was based on the fact that due to the issue of agency, due to us wanting to resolve the matter expediently. So even in this particular instance, you don't have it. Section 7.
No.
Okay.
You can carry on. No,
Yes.
I'm fine. Sorry, I'm under two different kinds of pressures here. I promised the chairperson that I'm going to finish this section, and I'm hearing whispers about aeroplanes behind behind me.
Okay.
So yeah, no, I think Tsapo, you've got it under legislation, section 7.4.
Yes.
Yes.
No, 7.1. You see, it's yes, section 7.1 E
Roman 1.
Roman 1.
Mhm.
The format and the procedure to be followed in conducting any investigation shall be determined by the public protector with due regard to the circumstances of each case. So this is used sometimes where we want to, what format can we take in fast tracking or getting cooperation from anyone who would want to investigate. So I think the question was why issue a subpoena as a first point of call besides the issue of the strike rule. So in certain circumstances, we require, or I then determine that, can you go ahead and issue, prepare a subpoena? Can we request for subpoena and affidavit from this person so that we can, as part of information gathering. So this is the section I was referring to. Thanks.
Thank you, Chairperson. Chair, I see it's 10 to 5 and we still have to address the big issue. Firstly, let me indicate that will be the end of the rogue unit issue, subject to the usual disclaimer. If there's anything to sweep up at any stage, I will then ask for permission. But for all intents and purposes, Chair, that concludes that section.
Thank you, Advocate Mpofu. We will quickly take 5 minutes stretch break and come back and then listen to your big issue.
Okay, thank you, Chair.
Recording stopped.
mini last stretch to conclude the day. I forgot it's Friday, but we're doing work. We're working.
Yes, no, we are.
Thank you. Over to you, Advocate Mbofu.
Thank you, Chair. It's a good thing you forgot it's Friday, so that you don't sympathize with the whispers I've been getting. Chair, yes, thanks, Chair. This is an issue we wanted to raise from Tuesday when we got here, but you had indicated that we should raise the issues at the end of the evidence. And that's why we've been keeping on trying to address this issue. Well, Chair, it's an issue to do with the letter that you received. It was copied to you. It was sent to the public protector actually, and copied to you on the 1st of March. And we just wanted, we thought it would be a courteous thing to indicate. I said to you jokingly in the morning that we should have brought you cake for lunch because and wanted to know whose birthday it was. And I said, no, it's not the birthday. But the serious part, Chair, is that it's regrettable. I'm now speaking on behalf of my legal team in particular, but also the public protector, that it's regrettable that we have to announce that today effectively marks the end of the road for the public protector's legal team. We had hoped that between the 1st of March and now there would be some miracle which would resolve the impasse that was caused by the letter of the acting public protector, Advocate Galeka, of 1st March, which he had addressed to the public protector to indicate that they would not longer be able to fund her legal team. I know that the committee discussed this matter and you indicated to the committee correctly, and so did the members, that this was not really your issue. Your task is to conduct the inquiry. But I think in the spirit of wanting the inquiry to proceed efficiently, obviously, even though it's not your issue directly, it is your issue indirectly at least. And we understand that that is in that spirit, Chair, that when the related issue was raised in January with you, you had kindly assisted, even though technically speaking, it's not your issue. And in that vein, I think we're also aware that you were involved behind the scenes with some of the ways to deal with this, as was discussed in your meeting. But the reality is that the correspondence that has been exchanged, even up to this morning, I think was the last letter that was sent. It has been made clear on the side of the PPSA that their position has not changed. And of course, our position also has not changed, as articulated to them on Monday or Tuesday, I think, or whenever this week. Yeah, so the long and short of it is that there's a legal debate about it, which doesn't have to concern you, but which maybe one day will be resolved somewhere. But it's really around the issue of, I think everyone accepts that the public protector is entitled to legal representation as was determined by the Constitutional Court after a long battle. Everyone also accepts too that in the suspension letter sent by the president on the 9th of June, 2022, it's clearly indicated there that the public protector would continue to be entitled to whatever benefits she was entitled to. And so is the presidential minute that was signed by the president to effect that suspension, that illegal suspension. So that I don't think there's much debate there. I think the debate is then whether that burden should be carried out by PPSA or whichever organ of state. We have no interest in whatever organ of state has to execute that duty, if there is such a duty. Yeah, so that's where we are, Chair. And but our position is that clearly the state bears that duty in whatever guise. And then because in the absence of that, it would be that the public protector bears the duty. I don't think anybody rightfully can think that. We've been told many times here that this is part of her accounting function. And it's not the first time that she's accounting to Parliament, if that is the case. She has testified that she has been here several times to give annual reports or whatever. And nobody has ever suggested that she should carry out that function. I think all state functionaries know about that. Now, Chair, the last thing I want to say, because maybe the public protector might want to say something about this as well, is that regrettable as it is, we see this, at least ourselves, as part of the campaign really to vilify and basically besmirch the public protector, and in this context leave her out there to hang and dry.
Just walk with me.
Yes.
When you say you see this as a campaign, what that is?
No,
the issue you're talking
yes,
about.
yes.
The
issue. Yes. No. Thank you, Chair. Sorry, I didn't make it clear. Yes. No, I'm just saying we see this as part of a pattern. Let me say of basically victimizing the public protector that she herself has spoken about, because we know where it started. We, she's been vilified, she's been insulted, she's been illegally suspended, and now the last straw is that she is being again effectively denied her right to legal representation, because that's really what it amounts to. So I'm saying it in that context, Chair.
Now I follow you now.
Yes, thank you. We know I don't have to walk that road again. The judges have said it themselves that she gets targeted with automatic costs, and the executive has illegally suspended her. So it looks like every arm of the state wants to have its turn in persecuting her and treating her like this. Not to mention the media, other racist organizations, and clever blacks who are not so clever. So that's really the context in which we see this, because it just came as a shot in the blue. We don't know what happened. All of a sudden, everyone doesn't understand that there must be assistance given to the public protector. And we suspected at a point that it was just driven by the lack of funds, really. I'm now speaking for myself. I don't believe that anyone thinks legally that this is not something that should be done. But one can be sympathetic to the fact that maybe there was some crisis, but from which people tried to manufacture a legal argument about the non-entitlement of the public protector to legal assistance, which is just nonsense. So given the situation, Chair, and as I say, if she so wishes, she'll also speak for herself. I think the way we lawyers always put these things in nice terms. So when a situation like this happens, we simply say she's not been able to give us further instructions to continue beyond this point. And therefore, our instructions are terminated. And when it became clear that that was the case, then obviously she indicated to us. Unfortunately, then there was the issue of the illness that interfered with this issue, because actually we had hoped to resolve it around the Sharpeville Day holiday, but then the public protector fell ill, and so we only were able to consult on it on Sunday, Monday this week. So that did put a bit of pressure on the communication. But because I think I had promised you on the week before, either I had promised you or you had asked for it in a letter, I can't remember, that we raise or we respond, I think by Monday, and we only did that by Tuesday or Wednesday because the sickness had intervened. But other than that, Chair, that's it for us, because we are now have other legal engagements. Because once she indicated that to us, of course, unless if we wanted our children to have no bread on the table, then we tried to wait for the miracle. But in any event, the miracle hasn't eventuated up to this point as I'm speaking to you. So it looks like we took a good decision by not believing too much in miracles. Sure. Okay, thank you, Chair. It looks like I have expressed the position of the legal team as such, and maybe while I still have instructions for the day, I can ask the public protector to make her own comment. Because after that, I won't be in a position to ask her to do anything.
Just to check, are you done?
I'm done on my part, Chair.
Thank you, Advocate Mpofu. I don't know if you have heard that, PP. Can I hear you?
Thank you.
I don't want anybody to speak on your behalf. You here in your own leadership role as you account to Parliament. So don't be surprised when I say on your own, because you're constitutionally here.
Okay.
Thank you. Go ahead.
Thank you for that clarification, and thank you for that opening that I'm constitutionally here. As the Public Protector of South Africa, I didn't bring myself to this committee. I think, Chairperson, I've mentioned several times. And since the beginning of the hearing, we indicated that I'm participating under protest. Remember, we even indicated that, can you wait several times, wait. We are taking this matter to court so that we don't continue doing the work, and paying the legal team until we know the legal standing. Indeed, we continued. We also now brought the matter of your recusal of the chairperson's Honorable Judge's recusal, Honorable Mileham. We said, can you wait? But we are continuing. And even the unlawful suspension or illegal suspension, we also said, let's wait. So all those were in the trying, Chairperson, to save the resources and the costs. And so that when we continue or when we focus, we deal with the matter and speedily. Remember, Chairperson, at the beginning, there was a number of withdrawals which were made by the Deputy Public Protector. So unfortunate that now she will then decide what I am supposed to have as the Public Protector of South Africa. I don't know where she gets that particular mandate. But this is how I'm being treated. I think I've mentioned several times as well, the issues of security, the issues affecting my family, withdrawal of, in fact, the issue of security, for instance, and reporting about some security threats which I was experiencing. But at the end of the day, who do one report to? Nothing is being done about that. Now here in this letter, I'm told about overspending in budgets. The legal team didn't know that. At first, yes, they planned for 35 days. Now 35 days became how many days? So you can't blame us. Yes, they need to plan. It's true. Hence, I even said to you at some time that possibly ring fencing or requesting money by then with the assistance of Parliament or approaching Treasury, it's one thing, but apparently they tried. But my issue here is that now I'm being blamed as if monies have been spent, as if it's my process, I brought myself here, and the fact that there are matters which the legal team is doing where she withdrew representation of those matters herself and the CEO. The legal team is doing those matters in court on their own. Now, when I told them about this process, that she wrote a letter and then she says they won't be paying anymore beyond the current financial year, 31 March 2023. I spoke to the legal team and they were saying, hey, PP, they are doing a lot anyway of those other matters we are trying to resolve, just to make sure that this process is a legitimate process, but as well just to bring sanity to the whole process. And that issue of them continuing with this process, it couldn't bear anything. I think I've raised it in previously that, I mean, the office even went further to even participate in court processes, sending legal teams, having to pay senior counsels to spend 2-3 days there. So, you know, when Mkhwebane is saying, do unto others as you would want it be done unto you, forgetting the very same thing that they are spending resources of the institution. But when it comes to this process, because at any rate, if I was just Busisiwe Mkhwebane working in state security or at Home Affairs or anywhere else, I wouldn't be sitting here. I wouldn't be answering. Now also the issue of the perjury allegation, they are saying they are no longer going to pay beyond 31 August 2022. That matter as well was brought because of the doing of the work, the CX matter, which we are still going to present and even show ukuthi kwenzakaleni. So, and the issues which is happening in the office, they are continuing to spend when it's about them. They can then travel, they can use all the resources. There was a complainant who was disgruntled, threw stones at the office. Then subs had to deploy 2, 3, 4 cars, which is who's going to pay for those? It's not subs. Still, they will be taken from the resources of the state. So if you balance all those things, and I just get a letter like that, and I'm being told the legal team won't be paid. So now I don't know what else to do. I don't have the resources, Chairperson Mina. I'm here because I've been brought here. It's not my process. And at the end of the day, you were copied, I think, Chairperson, in those letters. The chairperson of the Portfolio Committee on Justice was copied. The Speaker was also copied. But then this continuous process or this continuous treatment which I'm receiving, you know, from all angles. Now I'm blamed that the this inquiry has spent so much, forgetting as well the very same media to report how much Parliament spent, how much each and every legal representative has spent. So I think, Chairperson, it's not fair for one to be treated like this. And I think Advocate Galeka and Ms. Spanioni, they just need to assist this process, forget about what they are being told or how they deal with this particular issue, but avail the resources. And on the other hand, we are busy preparing. On the other hand, one is receiving letters like this. So now I need to be showing the legal team, but now we are busy with statements. I'm sick. So it's a very painful process for one to go through, Chairperson. So I don't know then what is the way forward and how can this matter be addressed? And it means if I don't have the legal team, I don't know how we are going to proceed, because we can't proceed until such time this matter is resolved. And now when they say they were accepting a number of work, which I heard, well, yeah, because they will be discussing amongst themselves. Advocate Mpofu saying, I've got 2 more. This one is saying, I'm busy with this. I'm traveling to Limpopo. I'm traveling to KZN, somebody else. So, yeah, Chairperson, I think it's in your hands. But I think the treatment I'm receiving is very, very unfortunate. And it's as if I'm this passenger on the street. I think people just treating me or as if I'm not the public protector. And I think it's not right for Advocate Galeka and Ms. Sibanyoni to do this. And I don't think there's anything even stopping them. Yes, the last time our interaction, it was still not, it was a shocking process one had to go through last year. But why can't we sit down and talk? Why can't we resolve matters? And now, you know, the position I'm at, it's another situation, because you have just received letters, we won't do this, we will do this. And as if I'm no longer the public protector, unless they know something which I don't know. Thanks, Chairperson.
Thank you, PP, for those comments. Let me just check. Is there anybody else from the members who wants to make any comment? Because when I responded, I will also be making a ruling, and there's not going to be a discussion after that. Are there any members who wants to engage with this by way of clarities or whatever? I'm going to invite you to do that now. I see Honorable Sukas. I think I have Honorable Sukas at this stage. I don't have any other hand. I'm going to recognize you.
Good afternoon, Chair. Good afternoon to everyone that is there at M46 and to all the members on the platform. Chair, I think it is important possibly for us to retrace, because before I do that, actually, I think I need just clarity in terms of victimization, as mentioned by both the legal representative and the public protector. In this context now, whether they are including the committee in that victimization or feeling of being victimized by the notice on the payment of legal fees up until the 31st. And the reason why I'm asking that is because at the beginning of the testimony of the public protector, both Advocate Mpofu and the public protector referred to the treatment of the public protector by various members, without mentioning obviously names. But I think it would be wise for us to really know who is included in the victimization as stated by both the public protector and a legal representative, and whether this committee is being included in that. This committee meaning the members of this committee, including the chairperson. Then, Chair, just in terms of the last several months that we have been going through this process, it is important for the record that we need to firstly, again, go back to the beginning when we said the process in itself was to be fair towards the public protector. And I spoke specifically in relation to the treatment of witnesses at the time. And so did Mr. Honorable Hendricks and I speak on the issue around timelines. Because we, at that time, highlighted there are millions of South Africans who does not have access to this kind of legal representation that the public protector has now. And it is within that context that we need to look at the amounts of money that we are spending in the process, as well as the adherence to that process and the recognition of the process as a way of oversight. It is important for the record that it must be recognized. We cannot look at it in isolation. We must also look at the fact that the consequences of the time spent unnecessarily for days on end on issues that had a severe impact on the timelines, had a severe impact on the budgets that are being spent and the money that is being spent here. The cost of that is also to the millions of South Africans. Because as I indicated to you, Chair, this morning at 7 o'clock, 6 o'clock in the morning, it was with poor South Africans that I stood on the side of a road to have a meeting. And tomorrow that I'm having a meeting with farm workers who does not have the money to defend themselves, and which amplifies actually the office of the public protector. So it is these many Gogothlaminis that we've been hearing of that are being affected by the timelines when members are not in constituency. They are prioritizing, as I am prioritizing, this process here. And it needs to be noted for the record as well. This is all of the chickens coming home to roost. We said this is a meter taxi. It keeps on running, and there is a responsibility to be bared by the public protector's legal representatives. I believe that they carry a responsibility not only to her, but for the office which she represents when they represent her in the manner that they represent her, and the cost of that to the South African taxpayer. It cannot be looked in isolation. There is a cost here, and that cost is being bared by the South African taxpayer and by the millions of people that does not have access to a legal representative. I want to put that on the record. Thank you, Chair.
Thank you, Honorable Sukas. Points noted. I see Honorable Nkosi.
Thanks, Chairperson, and good afternoon to yourself and members of the committee, the PP legal team, and the evidence leaders. Chairperson, I think we facing a situation that we predicted will happen some time ago. Previously, as a committee, we had tried to intervene in this type of matters on payment. And even when we did so under disclaimer that we should not, as the committee, be seen to be involved in matters of the executive where we encourage as parliament the entity or any other office to incur unauthorized expenditure. And that's a matter of not only of principle, but it's a matter of law. We conduct oversight over these institutions, and what we did by intervening, we did say is not creating precedents. That's the first point. The second point, Chair, is that I do hear what the public protector and the legal representatives are saying, but the principal question to ask is, who bears the responsibility really to pay for legal costs when you are engaged in this type of process, be it unique as it is, but generally all other similar processes in the state. You know? So I am inclined to say that the responsibilities between the public protector and the PPSA to negotiate an arrangement. We cannot be drawn as a committee on this process because of the point that I made earlier, that we are the legislative arm of the state, and it can't be at our prompting that unauthorized expenditure be incurred. And in that regard, Chair, I would like to really submit that we have a program. We've communicated the program. We've revised this program up to time, largely to accommodate the PPA, the public protector, and to allow more space and the legal team. And therefore, I suggest, Chair, that we stick to the program. The public protector has a responsibility to ensure that he has legal representation that's paid for. Any other thing between herself and the current arrangement with the PPSA cannot be a matter of this committee chairperson. Yeah, I don't know how you are going to summarize it, but I'm just saying that I don't want to get into issues about costs, etc., how much it has cost up to now. I'm just saying that we have a program and we must stick to that program, and that the public protector has a responsibility to avail herself as we move towards concluding the process. Thanks, Chair.
Thank you, Honorable Nkosi. I take it there is no other member, because I will not go back to those hands. There's no other member who wishes to make any point, that it's only those two members, because I've not seen any other hand.
Sure.
Agreed? Thank you. Now, maybe before I come in, just two questions from my side, and I'll start with you, Advocate Mpofu, and you can raise any other matter that you
Yes, thanks, Chair.
you were rising on.
Okay.
So as you make the point you want to make, well, you might as well just clarify this question that is coming to you. It will also go to the public protector, and another question to her. So I have received this letter today, and so have you, because we copied, all of us almost sent at the same time, whether it's whatever time this morning. Because I need you to just clarify one thing, because by the time you receive that letter, there would have been a scheduled program that doesn't end today. That goes on, and I'll be interested if having that program, which is dated, timed, and as days, whether it is true that even before the letter arrived, you would have taken other opportunities and jobs, or if you would have done that this morning when that letter arrived. I think it will be important that one gets that clarity. And so as you make the point that you want to make, so that we have that on record.
Yes. No, thank you, Chair.
Here.
No,
And then I'll go to the public
the
protector.
yes, thank you, Chair. No, in fact, let me start with your question because I think it's relevant to what's going to happen next. Yeah. Chair, I don't know which letter you're talking about, but we haven't received any letter today. But we sent out a letter this morning, which was in response, excuse me, to a letter that we received from the PPSA a day or two ago. It was one of two letters, but we've only responded to one because that letter, the one we responded to, requested to be answered by today. That's the one from the attorney. There's another letter, a separate letter, which was written to the PP herself. I think it was also copied to you in response to the one that she had written on Tuesday or Wednesday. That had no deadline, so she has not responded to it, to my knowledge. Yeah. But the one that we responded to, Chair, was about, it was, I don't have it in front of me, but it was a letter basically which said in a nutshell, can you give us an estimate? But our position has not changed that we cannot fund effectively. So it was almost contradictory. And then we said in the answer, we can't do that because for three reasons. One of them is that, and Advocate Bauer will confirm this, since Tuesday, we, in the so-called backroom, what it's worth, we've been talking about trying to, you remember the letter I wrote to you where I had said we will engage in the backroom to try and adjust the number of days required and so on, hopefully without changing the end date, because we know that there has to be an end date. And so we were involved in those discussions again when we were still under the hope that some miracle will happen. But we basically abandoned even those discussions 3 days ago when it became clear that, at least from our side, that no miracle is going to happen. So the reality, Chair, is that by yesterday, we received a letter that confirms the position as that it's the same as it was on the 1st of March. So coming to the other issue, we had, when it became clear, or as it became clearer that, and again, for now, I'll speak just for myself, that the PP indicated to us that she won't be able then to give us instructions, then obviously we could not say no to other work. Speaking for myself, I'm now immersed in some matter that you might know about a certain Mr. Bester. So even now, as I was cross-examining, I was seeing missed calls about that. So the way the practice works, Chair, is that you always get approached for things and you say you're not available, but you can't say you're not available if you are, or if you don't have a competing instruction, so to speak. Yeah. So that's the situation as far as the work thing is concerned. But Chair, so the program that we were negotiating, I think, has not been concluded because obviously it needed to be brought to you at some stage or to the committee. But we don't know if that will ever happen, or it might happen with a new legal team or whatever is going to happen. I mean, I don't know. But so that's the issue about availability. But again, that might not be relevant because even if we had no other work to do, we could not in any event continue on Monday without instructions. I just want to, as I was saying, I wanted to just respond to the question directly put by Honorable Sukas. And maybe I should start with Honorable Nkosi. Honorable Nkosi, this is an important thing because I think for the first time I agree with him wholeheartedly. Well, not wholeheartedly, but almost. That
Just take heart, matters of heart
out of it. Yeah, thank you, sir. No, but no, he's right that, and I've acknowledged this. This is a matter for the executive. The committee is really, to the extent that the committee was involved in it, they were assisting us, and it's always been made clear, even by the chair, that he was assisting us insofar as it obviously has an indirect bearing on your work, but we've never, it's not something we can settle on the committee, however much we like to blame the committee. So it is the matter that's going to be resolved at the appropriate level. When we say it's the state, whether it's the treasury, it's the PPSA or the presidency or whoever, but somebody must resolve it. Yeah. So that's where I agree with Honorable Nkosi. And this is not the first time this happens. Advocate or Ms. Matonsela told you that when she started with the Zondo commission process, she only needed 3 million, she says. I thought it was 130 million, but they ended up spending 2 billion rand because these things do take time, and fairness doesn't, means that sometimes you have to extend, and Chair, you've gone through the whole drill. And the issue, what I really what is disturbing me are the comments of Ms. Sukas, because firstly, let me allay if we sounded as if we're blaming the committee for this, Chair, then we apologize for that, because that's definitely not our intention. As I've explained, the committee, quite frankly, has got nothing to do with this. And we're grateful for the interventions of the committee when that was done. The committee, we blame the committee for various things. And we even ask for a recusal of its members and whatever, but we can't blame it for something that is not in its province. The only thing really we can blame the committee for in this connection has to do with what Ms. Sukas is talking about what it has taken. We said here from day one, apart from the things that are enumerated by the public protector, where we have, from February 2022, we've been saying, for example, when we go to court, let's hold the proceedings so that we don't waste time unnecessarily and money. And every time this committee has rejected that. So maybe the committee can take blame for that, but that's a separate question. The other issue is, when we started on the 11th, we said, let's proceed with the scope that has been defined by the independent panel. And the committee rejected that as well. I have no doubt that if we had done that, this process would have been finished maybe in October, or November, or whenever. But the committee decided it wanted to go the long haul and include matters that are not part of the independent panel's report. There's nothing we could do about that. So, it's very easy to throw stones, but you'll find that 3 of the fingers are pointing at you. So but I call it a South African sport, this thing of blaming the victims. So now it's our fault that this impasse has been brought about by Advocate Kaleka or whoever else is involved in this. It's the fault of the public protector, it's the fault of her legal team. But that's what, as I say, it's a national sport. when women get raped, it's because they are wearing a short skirt. So we're used to that. So we're not going to take any part of any blame for this situation that we did not create, and neither can the public protector be expected to shoulder the blame for it. It doesn't matter what anyone has to say about it. And yes, we agree, we cannot look at the process in isolation. And I don't know what it has to do with millions of South Africans who don't have money to have legal representation. Well, if the committee sympathizes so much with those millions of South Africans, it must also discard its legal representation in the form of the evidence leaders and any other legal representatives in solidarity with the poor that Honorable Sukas was standing with on some road somewhere. Yeah, so that's the position, Chair. It's not of our making, it's not of your making, at least in our estimation, but it is what it is.
Thank you, Advocate Mpofu. Back to the PP. The question first to start with from my side. Maybe I'm going to start where he responded to my first question about the issue of taking other jobs, opportunities, because I would want you to place that on the record. And that's point number one, because they work, they're here working on your behalf and for you. The second point is, so 30 days ago, and I think Honorable Nkosi is correct, and we'll have to stay in that lane. We don't want to straddle lanes. We've been very consistent with that. 30 days ago, meaning the 1st of March, you would have received this letter, which as a chair was copied to and shared that with the committee. And amongst other things, that letter indicates that by today, there would be no funding for this process from the PPSA. I am not, the important part would be, as you engage with them, we would be interested, perhaps even outside of this meeting, as to within that 30 days, what kind of engagements would have happened based on that letter. And he's pointed out that letter. I'm curious about that. We'll in our own way or through the relevant committees, whether it's justice and so on, would have to inquire as this committee about what work would have happened in that regard in the 30 days where a notice has been put. But the last question that I will be happy that you speak to us about, it's just a simple one. Now that you have put what you've put here, PP, so what are your intentions now? That's the question that I would like you to respond to. Thank you.
Can you clarify, Chairperson, after receiving a letter, engaged with a team? Did I engage with a team, or with who? You mean me? Engaging with a team and with who? Okay.
No, the clarity is that, and this is, you receive the letter from the institution that supports you in these endeavors, which is the Public Protector South Africa, but I don't want to individualize it.
The office, yeah.
Yes, the office, which then said on the 1st of March, we're not able from the 1st of April to continue with any funding in relation to this inquiry. This is what they said in that letter, which we received. And so the point that I'm curious about, that I'm saying we're going to have to take up, because you have no burden to explain that to us but we'll have to take that up with the Justice Committee to find out as to, with those issues that were put there, because part of what that letter says that there needed to be a discussion about what's the next plan to offset what would have been that kind of challenge. I have no picture of what would have happened in 30 days to attend to those matters that were raised until there's a further letter that confirms certain things. I hope I'm clarifying what I'm putting to you. So it's not the legal team that I'm referring to.
Or to find other ways.
Yes.
Chairperson, I think, as I said, after receiving the letter, I think 2 days or a day or whatever after, I forwarded it to the legal team. I forwarded to my family to inform them about this depressing issue. When I'm busy with the hearings, on the other hand, I'm told that we won't represent you. I must also appear to court. But then engaging with them to just continuously saying, you are doing the other court cases for me. This is also one thing which is now coming up. And I wouldn't approach the chapter. I don't know whether I must, because remember I'm suspended. And firstly, what Honorable Nkosi is raising, well, and unfortunately, my legal counsel is agreeing with it. But on the other hand, accounting to Parliament, remember this is a parliamentary process. This is the process which was approved by the National Assembly. So in hindsight, what I would say is that addressing the way of going forward, because raising it with my family, my husband was also trying to find ways of checking what can be done in this particular issue. Firstly, I will never pay for, I don't have, I mean, with the court clobbering me with personal cost, and to even think that I must pay that because I never brought myself here. This is a test case. You've been saying that yourselves. There was never a time where a person like me who's working for the state is brought to account. In a normal labor relations matter, indeed, an employee must bring a union member to represent or get their own legal team. In the past, during apartheid, issues were Bason and everything. The state paid for their legal costs. It was another different arrangement. My case, I didn't bring myself here. It's a determination of fitness to hold office. The proposal going forward is for me proposing to the chairperson, we're using the same fiscus and the same resources. And to answer Honorable Nkosi as well, Guti, and Honorable Sukras, I'm very much concerned about the resources of the state. And I'm not saying PPSA, CEO, no Galega must violate the legal prescripts, PFMA and everything. But I'm saying in the process, NABO, they should have also engaged me, or alternatively, when they speak to you, why can't we then tap into the very same resources you are using to pay AMA evidence leaders? And then a speaker, because it's his process, it's her process actually. Why can't we then go there? In National Treasury, if we avail AMA resources for this process, let them avail process the money for that particular process. But Mina, I won't. And unfortunately, Chairperson, I will be appearing, and I was going to ask you and plead with you that can I appear online as well, but there won't be anything which I'll be saying because I wouldn't have a legal representation, and the Constitutional Court judgment is very clear. Legal representation of my choice. Maybe let's not engage with Galega and burden them possibly. But Mina, I'm bringing it squarely to this committee because it's a parliamentary process. So I think wherever you get the money. And the members of the public, I know the media is saying I am running away from the process. And I want this process indeed. And hence I said, I appreciate it so much, and to clarify the information, but as well, can we use the same fiscus? Thank you.
Thank you, PP. Those points duly noted, those contributions. I take note of them. I see your mic. I wanted to make a summary now and rolling, but let me hear you out, Advocate.
Chair, I just wanted to clarify and agree with Advocate Mpofu that we didn't conclude our backroom negotiations, but I think for different reasons on our side, Advocate Mpofu had endeavored to negotiate with us on Tuesday. He was very excited on Tuesday about getting the Mr. Bester brief, even then already. And part of the difficulty was that the end date of any revised schedule was the 29th of May. And we had then been reliably informed that the criminal trial that Advocate Mpofu is involved in and had already been arranged in November to run for 2 terms. Am I correct? That's scheduled to start on the 17th of April. Is that correct, Advocate Mpofu?
No, well, you have more reliable sources than me. I don't know anything about that, but I'll take your word, yeah.
So it did seem, Chair, that we needed to, rather than have expansive days, have lesser days in doing this. And so the communication had ceased because it didn't seem that there was much point in having expansive dates.
Chair, if I may, I know, just to clarify that point.
Don't get provoked.
I know, no. I'm not being provoked. I'm just.
She was the last one to speak.
No, Chair, I know, before you summarize.
Okay,
No, it's really just a matter of clarity, just to allay any fears about that other matter, the criminal matter. I mean, so that I'm not opportunistically using that matter. I had already made, even before this, arrangements with my team that if it does proceed, that matter, I would have been engaged here. So it's other matters, not that one. That one would take me out for months. Yeah.
All right. Thank you for those clarities, colleagues, honorable members. Maybe just by way of summary, Honorable Sukas, you have your hand up. I want to summarize so that we wrap up.
Yeah, Chair, I think it would be, Chair, if I may ask, I see that you're frowning. I don't want, shall I proceed with what I want to ask?
I don't know what you want to ask, so you would have to proceed. I did indicate earlier in the week, 2 days ago or yesterday, to the public protector and Advocate Bauer, never to follow my body language because it would be very confused. Go ahead.
Yes, thank you. Chair, I think I want to make a comment and then just ask the question, which is that as part of the responsibilities of any executive, as has been mentioned, I think, by the public protector before. And I think she reiterated it now when she said that she is the public protector. We need to do things within the limits of a budget, right? And that is part of the performance indicators for departments as well. So I think it would be, the question that I want to ask is, what is the current cost up until today that has been paid towards the legal representation of the public protector? What is the cost standing at? If we can get an indication of that, what it is up until today, the 31st, when PPSA has now indicated more than a month ago, actually, to us that they cannot do this. Because the reason I ask that, we are accountable to the public. And we have made this point that this is a meter taxi that is running. Every time wastage, every shenanigans, all the theater, all of that comes with a cost. And so I would like to get a number, Chair, For the record, how much has been paid up until now? Thank you.
No, thank you very much. You will get that number, not in this meeting. We will find a way to forward that to you. I'm not going to open that door now. But that information would be readily available to all members. So let me therefore with that proceed. Maybe I need to start, just walk back. A week ago, we had a committee meeting in which, and you'd have made reference to it, in which in our own sincere and difficult discussions, we identified a number of risks that are facing this process. And would have summarized them into 3. I'm not going to go back into that, but they had to do with the risk of what that letter raised of the 1st of March, the finances. We considered that as a serious risk, and we had an honest discussion about it, including the need for those risks to be mitigated by the relevant stakeholders. We still hold into that position because that risk has now materialized. There's no doubt about that. So it was when we discussed that, we did not throw our hands in the air and say this, now that we have this risk, everything stops here. We were very clear in our mind that we're engaged in a very important process and that there is a need for us to be very much alive of those risks. Was the second risk was the issue of the members, the issue raised by Honorable Sukas that they're involved in other activities, which I explained yesterday when you were checking the attendance. We identified that as a risk that as we are going to be meeting next week is constituency period, and we should be with what Honorable Sukas has already started. And the third risk was we do not want an unending process, a prolonged process. And we've been very much insisting on that, even when there were requests to expand and so on. And so I want to start, therefore, in responding to this, I think. So, of course, I would have asked the questions I wanted to ask from the PP. It's clear that what you are placing here, because we can't say we're surprised about it. That letter warned us about that risk. We are aware that there were a number of key role players, once that letter was received, who started playing a role. Maybe what they would have come to is not adequate as required by the process, and therefore more mitigating measures must then be insisted on that. And quite clearly, this is a process that office, that institution needs to see through. This is a process that would be unfair for the public protector if it just ends in the middle of it, especially her having started. And by today, we have concluded the 2 charges. We've concluded part A. We have already received part B of the statement. From where I'm sitting, that does demonstrate readiness to be subjected to the process, to be part of the process. I'm not in a position to read anything else unless I'm too slow to read that, in which case when I finally read that, I'll make up my yes. So therefore in that regard, I think it's something that I'm taking it seriously as a shareholder. We're going to have to ring fence to take up the issue. It's not done by us to knock on the doors of those people because it seems that something was started which kind of reduced whatever load, but it's not enough to help us conclude the process in the way that it says it's ending today. That's the first point. I think the second point is with that having to be pursued and much stronger and with some urgency. Added to that, I'm still going to insist, PP, that all of us would have extra days over this weekend, because today we're on the 6th day of the testimony of the public protector. Initially, we scheduled 9 days because we thought that would do everything in that 9 days. And when it was 9 days, it was not a backroom discussion. The sharing of notes on the floor here between myself and Advocate Mbofu was that out of the 9, I need 6. So you wanted to take the bulk of it. But it's become clear once we started, and would have made correspondence to yourself, PP, about the fact that there would have been a request to say we need extra. We actually need altogether anything between 10 and 12 days in your correspondence. And so as a chair, it's going to be important that we're settling for the 10, which means today is a 6th day. Again, next week, you get the extra 4 days to make that 10 in terms of our program that we have. So because we still have to go through the CX and Friede and HR and whatever that he normally creates. Yes, but he has to do all of those things within the stipulated 4 days. So I'm indicating, therefore, from the chair that we're going to leave this meeting, PP, with the understanding, unless something else changes. And in the light of what I've indicated, that there has to be urgent mitigating measures to deal with the risk that you have, we will be back here on Monday, Tuesday, Wednesday, and Thursday to conclude the part with your legal team, and thereafter get to the evidence leaders and the members. It's clear now that that plan is going to be subjected to some work that would need to be done, but on record, that's what I want to place here as we conclude this meeting. I think I've touched this issue of the 10 days. I would not go because everybody else will get lesser days thereafter, because at some point we've got to conclude this. What I'm happy about is the fact that there's even further suggestions I think you've put on the table. I've taken note of those suggestions. Again, those suggestions are demonstrating to me that the issue for you at this stage is finance. It's that support. Advocate Mbofu says, as far as he's concerned from the state, the issue is not finance. I'm not going to ask him what the issue is. I'll leave him to make those, I'm not going to say conspiracies, but I'll leave that to him to do that. But I think it's important that we, and we're doing that also with the understanding that from next week, from Monday, National Assembly is in recess. There's no other committee that is going to be working. This is going to be the only committee that will be working, and because it is required so by the National Assembly. So there's some serious urgent homework that we need to take as we leave this room, because I think PP correctly, and I share that with you, this committee has made that point, it is not in our interest to force the office to do unfunded expenditures, but that within this state, we've got to find something to assist that process. I think it's important that one connects with that as an important issue wherever. I've got important calls it any of the organs of the state. It doesn't have to be the PPSA. So I think we seem to be sharing a common desire in that regard, because I suspect that if you are not interested to proceed and we are not ready, such ideas would not be shared in that regard. So I think that's where I would want to leave this and respond in that way. I think that then would be other issues that would can be taken outside of this meeting offline, and that we're going to need to have that hotline communications and engagement about what are the efforts that are being put in place. It's really the mitigating measures that we're attending to. So the time now is 6 o'clock, 8 minutes past 6. At that point, colleagues, I'm not going to invite any responses to this. We leave here with a huge task, basically, because when that is done, everything else falls into place. I'm not going to engage. There's no way we are going to stop prospects for other people who do their job, but those prospects are subjected to what they are occupied with, because nobody can take new prospects when you are involved in an assignment. That is very clear. And I'm not going to open discussion on that at all. So we can discuss that offline. So thank you very much, colleagues. The meeting is adjourned. Thank you.
Thank you, Chair.
Thank
Thank you.
you.
There are any prospects?
Thank